20. Huh? 12. Okay. Item 20 is for an adjournment. And list on 12. Okay. Next. For listing. Okay. Give it. I want to check the other side. Yes, please tell me.
Up to date CD not yet received, my lord.
Up to date case diary as call for not yet received. Issue reminder for the same. Interim bail is there.
Yes, ma'am.
Interim stands extended till the next date of listing. List on
8th of May.
28/5. Okay.
Hello, Mr. Up to date CD.
May I praise your lordship for listing of an anticipatory bill for
Okay.
obliged.
May I please your lordship? I would like to mention item number 39.
39
Nothing senior is out of,
for orders matter.
should may kindly indicate
Huh?
20 May.
20th May. 6 an adjournment to the of the matter and praise for listing it on 20th. 20. List the matter on 25. 20th May.
Yeah, please, your lordship. So item number 54, my lord, supplementary list. I have the case diary is not available.
Yes, CD not available, my lord.
12th or 13th, my lord.
Case diary is not received. Issue reminder. Fix on 13.
I'm deeply.
No.
Please, your lordship. Lordship, I beg to mention item number 28, lordship. Lordship, it may be listed after the week, lordship.
Item?
28. Learned counsel prays for an adjournment. The case diary is also not received. Issue reminder. Scan
Okay, received.
receipt. Sorry, a scan TCR is called for receipt. Full stop. When do you want it? After a week.
After a week, lordship.
List the matter after a week. Should we fix a date or leave it to registry? Can
We'll
fix
fix
a
a
date. We can fix a date. Suggest a date next week. 13, 14, 14. List on 14. Any interim order? No.
Yes, lordship. I'm on
Interim order stands extended next date of list.
Much obliged.
May I please, your lordship? We can mention item number 19, my lord. Can this matter be taken on 11, my lord? We have some difficulties today, my lord. I have informed amicus curiae.
No problem. 19, 6 and accommodation today. Stop.
11,
Fix
my
and
lord.
praise, fix on 11th.
And another matter, my lord, item number 37, my lord. The cancellation of bail, my lord, filed by the state, my lord.
Cancellation of bid. Okay.
So can be taken on the next week, my lord. 14, 15.
You file with the state.
Yes, my lord.
File with the state. So next week you can.
You want
Can you 14, my lord?
14.
No.
List the matter on 14th.
Obliged.
May I please, lordship. Lordship. May I mention item number 48 and 49, my lord. Hearing matter.
Okay.
Matter may possible for the day, my lord. 48, 49.
The only thing, okay, no problem, but it's a old matter,
Yes,
so
my
it
lord.
will be better to get it fixed on a Tuesday or Thursday. So it will automatically come in the, yes, next week we can fix it on for Thursday 14th, right? Let us fix it on 14th. Fine?
Once, can it be 22?
Don't take it on Friday, take it on a hearing day.
Hearing day.
Then it will
Yeah.
reach, because it is 17 matter, automatically it will come. 26,
Yes,
you will be comfortable. Okay. Praise for an adjournment, full stop. However, as the matter is old pending one, therefore fix it on 26/5/2025 in the hearing call. Okay? 48 and 45. Prepare it, and on the next day we can do it.
May I pray, your lordship? I beg to mention regarding item number 23 of today's list, lordship.
23?
Yes, 23, lordship. So in this case diary was called for, and I have received instruction that a charge sheet has been submitted. This is commercial quantity. At this stage, I am praying for calling for the TCR, lordship.
Could we take it up when it comes.
Problem.
Motion be item number 1.
Here will be required, Lordship. Entire commercial quantity involved, Lordship.
Its trial is going on. Trial is going.
That is good.
Trial is-
The sheet submitted.
Yeah, Midland Council, KK call for the scan TCR of special NDPS case number 60 of 25, within bracket, arising out of Karimganj PS 250 of 25. From the court of the learned special judge Sri Bhumi. Also, the petitioner is in custody since 22/5/2025. Scan TCR within bracket, comprising case diary, charge sheet, depot, other relevant documents. List on. Just a minute. It was earlier directed to be listed before Justice Kolita. A. Kolita.
Co-accused was granted bail by the coordinate bench, therefore it was directed, but that bench is not available,
No.
Lordship, so it will go as per roster.
Okay, later it can be posted there if necessary. So when should we fix it?
Lordship, may I pay for a short date because this matter is pending since 9/3/26.
Okay, no problem. Take it next week. 15, Friday.
Can it be on 18 or 19 because LCR
No
will not
problem.
come, 18 or 19?
18.
How does
Item number 2.
Please, Lordship. It's an FIR, your Lordship will find at page 10, my lord. The relevant is page 16. NDPS case, my lord, this commercial quantity, my lord. This upon my lord, credible information was received, my lord. The police force went to my house, my lord. That my husband is a drug peddler, my lord.
Okay.
I am a newly wedded bride, my lord. My marriage was solemnized on in the month of February, my lord.
He was also arrested?
He
I
was
see.
arrested, my lord. What happened, my lord? Page 10, my lord. I will rely, my lord. Your lordship sees, my lord. General diary reference entry number 1, dated 25/4/2026, my lord. This lady was arrested without any ZD entry, my lord, without any FIR, my lord.
No, she was, the search was conducted pursuant to information, perhaps.
My lord, at night she was, my lord, detained, and next morning she was arrested, my lord.
The GDNT is dated 24/4.
24. Okay.
As for FIR, my lord, it is 24/4, but in page 10, my lord, it is 25, my lord. My lord,
Anyway,
kindly see, my lord, column C, my lord, general diary reference, my
Is
lord.
there necessary?
case diary will be necessary, but we'll see it, no problem.
My lord.
Whatever it is, because of the recovery, she was arrested anyway. Heard, call for the case diary of Dolgaon PS case number 63 of 26. So and so. The petitioner was arrested on 25/4/2026. Full stop. Give it within a week or so.
But-
Next week,
What is?
on 15.
15, my lord.
Huh? 15.
God bless.
Item number 3.
Yeah, please, Your Honor. Well, this is a case of person was arrested in a case, my lord, very unfortunate incident, but I don't think that the charge section absolutely not made out, can't be made out also because of the facts of this case, my lordship. will kindly-
Accident.
It's an absolutely case of an accident. No doubt it's a very unfortunate incident had happened. Page 20 and the FIR itself, it's allegation that I was driving in a rash and negligent way, but in the FIR itself, it was admitted that I collided with another roadside truck which has been illegally parked in the roadside unauthorizedly, and I have collided with that truck. So how can it be a case of an culpable homicide not amounting to murder, my lord? It is absolutely case, my lord, just to make it a non-bailable offense. The page 20 is the FIR. Second paragraph itself says that during inquiry, Lordship will find at page 20. During the preliminary inquiry, it was found that the Maruti so-and-so number coming so-and-so side towards the Margarita side collided with the Tata 07 so-and-so number, which was negligently parked on the roadside. The accident appears to have occurred due to rash and negligent driving of the Maruti Swift car, as well as negligent parking of the 407 truck. It appears, in fact, the truck driver was arrested. He was granted bail. Thereafter, my lord, what happened? This section was added just to make out a non-bailable case before my arrest, my lord, production of in the court. 105.
Anyway, we'll have to see the diary in this case.
Then, my lord, day after tomorrow, my lord, from it's a Nunmati only.
If it comes, no problem.
Okay.
Call for the case diary heard, Senior Counsel. Call Nunmati PSK 66 of 2026. Can you get it on Wednesday? Today is Tuesday, Wednesday, right? Friday. Okay, Friday we can take it.
Obliged.
List on. Try to 8.
Obliged.
Oh,
In this case, lordship is under NDVS section 21B of NDVS. Case diary will be required, lordship. May I pray it on 14, lordship, is from Satgaon.
Okay, no problem. 14.
14
Yes, Munir. Call for the case diary of Satgaon PS 44 of 26. Ulster. Fix on 14.
Much obliged, your lordship.
I
Yes.
May please, your lordship. Lordship, here in this case, lordship, 3 petitioners are there. The petitioners were arrested on 31/3/2026. As on date, lordship, they have completed 36 days. The recovery from the possession of the petitioner number 1 is 55 grams of suspected heroin. My lord, may kindly come to the FIR, page number 23. Nothing was recovered from the possession of the petitioner number 2 and 3 as per the FIR. Here, lordship, I am seeking bail on 2 grounds. Basically, lordship, the first ground is, lordship, the length of detention already 36 days and it is 22B. And second is that, lordship, they were arrested on 31st of March 2026 at around 8:57 PM and they were produced on 2nd of April. That is, lordship, very much after 24 hours. More particularly, lordship, the petitioner number 2 and 3. My lord, may kindly come to the FIR, page number 23.
But let us get the case diary. It will be necessary.
Only one prayer is there, lordship.
No question of interim at this stage.
That's so.
All for the.
One thing, lordship.
Yes.
My lord, may kindly come to page number 26.
Yeah.
Let the case diary be there. I'm praying for a short date. Prayer portion. 4th paragraph. Further, I would like to inform your honorable court that the arrested accused person,
They
namely,
have children.
yes, lordship, babies, lordship, with them and 36 days already, lordship. May I pray for interim bail for them, lordship?
And I will dispose it of together.
Then, lordship,
It's a drugs case. So
and
there are arrangements in the jail. I know they bring baby food also. Arrangements is that.
and another thing is that, lordship, particularly, lordship, that 24 hours violation is there. May I pray for a short date, lordship?
We'll see that.
Yes,
We'll
lordship.
see that aspect.
Sir, my lord.
You make a note of that. You address the court on that also regarding that.
Yes,
The date of arrest is mentioned clearly as 1/4/2026.
but in the FIR, lordship, it is stated that they were apprehended on 31st/3.
Yeah, please locate a specific judgment of the Supreme Court which
Yes,
says
lordship,
that
I'm
the
looking
date of
at judgment.
that the 24 hours is to be calculated from the date of detention. No, the other judgment which we discussed that day, Subras Sharma, that was in the facts of the case, it was indicated, but try to find a specific principle that it has to be calculated because the constitutional provisions says date of arrest, time of arrest, from the time of arrest. A specific principle that it has to be calculated from the date of time of detention. Okay, that is also necessary because police is making a lot of these mistakes. Anyway, heard the call for the case diary of Mankasar, PS case number 45 of 2026. He was arrested on, the petitioners were arrested on 31/3/2026. It is submitted that both of them have babies, no?
Both of them,
Both
lordship.
the-
Two petitioners are there, lordship. One is the male person and 2 and 3, both of them are having
Yes,
babies.
the petitioner number 2 and 3 have suckling babies with them. in custody, full stop. They were arrested on
31st of March, 2026, man.
31/3/2026. List on, you will give
Let it be on 12th, Lordship.
12, no? 11,
12.
12. Oh, 12.
Highly obliged.
Supplementary 50.
Please, my lord.
Yes.
Allegations of, my lord, under NDPS Act, my lord. Wrong section has been leveled, my lord. My lord, as per the FIR and the search report and everything, my lord, quantity of 255.56 grams heroin, my lord. Which makes
255.
it under 21C, my lord, commercial, as per the schedule.
Mhm.
But my lord, as per the magistrate's order, my lord, it has been categorically stated that the quantity is 235.63 grams.
Hmm.
If my lord may,
Rather, we have to go by the magistrate.
yes, my lord. Law is clear, my lord. Moreover, my lord, violation under, again, that
Initially, it may be, but ultimately, after sampling, the
Yes, my lord.
inventory is certified
settled
as
law,
that.
my lord. It will be intermediate. My lord, second, my lord, I am a driver, my lord.
Where is the magistrate order? I'll just
My lord,
take it.
kindly have page 33, my lord. Relevant is 38.
30?
38. 38 is the relevant observation. May I read?
Yeah, you can read if you want.
Yes, my lord. I'll start from 37, my lord. The seized suspected narcotic heroin in polythene packet suspected.
I found it also.
Mixed, yes.
No, I found it, no problem.
My lord, violation of the 47 notice also, I was arrested on 19/3/26. Notice was served on at 12:30 PM on the next day, 23/26.
Okay. So anyway, heard so and so. Call for the case diary of Jokhlabanda PS case number 27 of 2026. And so and so. Person was arrested on. When was he arrested?
19/3/26.
19/3/2026. Learned Counsel drawing attention to the order dated 20th March 2026 passed by the learned magistrate, AMFC, learned magistrate submits that the inventory, while certifying the inventory, the quantity of the contraband within bracket suspected heroin has been stated to be 235.63 grams, and therefore it is submitted that therefore the quantity in question would fall in the bracket of intermediate quantity. Though at the time of registration of the case, the police has given penal provision pertaining to commercial quantity. Is the matter, when can we fix it?
My lord, Jokhlabanda, my lord, maybe on 13th.
My lord,
13.
sorry, my lord. My lord, may I pray for an interim? Lord, the problem is, my lord, I have a 3-year-old baby, my lord.
No, drugs.
Yes.
So number 6. Motion may be.
This is second time bail application, Lordship.
So, no problem. Any submission or updated case diary shall we call?
Updated case diary, Lordship, at this. And because they are subsequent to that, Lordship,
No issue.
substantial progress has been made.
Okay, we'll hear on the next day. Heard, no? Mr. Doctor, who fairly submits that an earlier bail petition was rejected on 1/4/2026. Call for the updated case diary. Investigation must have progressed, maybe completed also. List on
18 May.
Can it be a little bit earlier?
Can be if it's possible on 15th or 14th. 14 or 15?
Probably.
15.
Number 7.
May it please your lordship, anticipatory bail application, your lordship. And lordship, POSCO is there. At this stage, notice may go to respondent number 2. Is there?
Okay. This is M. F. Learned Counsel.
F. Hussain, your
Sorry, I'm sorry. I know you too well. F. Hussain, Learned Counsel for the petitioner. Stop. So fairly submits that at this stage, perhaps notice has to be sent upon respond number 2/informant. Call for the case diary of Bongaigaon is 59 of 2026. Stop. Steps of notice shall be taken on the informant and I can do to the office of prosecutor. List on
20 May, my lord. Notice has to be served, my lord.
okay or little early you want
18, my lord.
18.
beg your lordship.
Item number 8.
Lordship, the matter may be taken up after some time, your lordship. Authorized.
No problem.
9.
Charge sheet
Charge POCSO matter, my lord, TCR has to be called and notice.
should be equal.
Lordship, accused is a lady, your lordship.
Okay, it's after some time.
9.
Yes, Mr.
Lordship will find the FIR, my lord, at page 10, my lord. Not a FIR name accused, my lord.
Case 10.
Page 10, my lord.
This was the
Now, my lord, here, my lord, the accused number 1 and 2, your lordship had protected, my lord. That your lordship will find at page 15, my lord.
much. Okay. This person is not named in
Not
the
named in
Let
that.
him record his statement. So no problem. I got it, Mr. and Dr. NJ Dr. Prasad. It will page 16 of the set 2 and 3 to do. Mr. Dr. Learned Counsel submits that the present petitioner is not named in the FIR. He further drawing attention to the annexed order, he further submits that two co-accused who were named in the.
Yes.
Actually, he is not an accused since he is not any named in the
Yeah,
FIR.
yes.
Two accused who were named in FIR were granted interim bail by the order dated. This is not disposed of, no?
No, my lord, it is fixed on
Oh,
15/5.
okay. On 8/4/2026 and AB 796 of 26. Call for the case diary, similar order to the, however, in the interim, same conditions, 25,000 with COD and same day, let us fix it on same
Yes.
list on 15/5.
I'm obliged.
Number 10.
May I please, Lord?
Yes.
My lord, accused convict not complied the judgment and order dated, my lord, 10/12/2025, my lord. Lordship court make a direction to restore the immovable property on or before 9/1/2026, my lord. Since then, my lord, already 4 months elapsed.
Oh,
With
that one,
the-
that case.
my lord.
Okay.
My lord,
That's what
only,
I'm. Yes, sir. Yes.
before filing the complaint case, my lord,
Mhm.
107 case has been filed that with the schedule, my lord, schedule of the property.
Mhm.
Thereafter, my lord, complaint case has been filed and along with the judgment dated 4/6/2010 and the 145, 146 petition with along with the schedule was placed before the Gorsuk police station. That is also not complied. So, my lord, as per the direction of the Honorable CGM, my lord, I was collected the 2 copies of the 107 and 145, 146, where there are the schedule, my lord. And in pursuance of the schedule, my lord, Lordship, the Honorable CGM could pass the order on, my lord, 25.
Mr. Islam,
21.
at this stage, I think let us issue the notice
My
at
lord,
this
my
stage, huh? And we'll see all these things. Anyway, heard Mr. B. Islam, Learned Counsel for the petitioner. The petitioner, namely so-and-so, has invoked the provisions under section 11/12 of the Contempt of Court Act, read with Article 215 of the Constitution of India, dash, alleging disobedience of judgment and order dated 10/12/2025, passed by this court in criminal petition number 709 of 2025, whereby certain directions were given to the respondent number 1 and 2, and compliance was directed on or before 9/1/2026. At this stage, steps of notice shall be taken by speed post upon the respondent number, the two respondents, that is respondent, the two respondents impleaded herein. This is the matter. After 3 weeks, after 3 weeks, let us fix a date. 28 or 29, 28.
28.
Hearing BA, item number 18.
My image on his legs on another.
After some time?
One.
Make please, your lordship. Let's say charge sheeted case, my lordship may kindly call for the, my lord, the TCR, my
It's
lord.
not come?
Not come, my lord.
Oh,
In fact, my lord, when we have filed, my
oh,
lord, that
there's only investigation was going on.
the TCR number, my lord, special NDPS case number 22
Okay.
of 2026.
It will be necessary, right? No. Trial has not started.
Not
That is
started.
Not started. The doctor, I don't know. So, it is submitted that in the meantime, as charge sheet has been submitted, therefore, the scan TCR may be called for. Accordingly, call for the scan TCR of
Special NDPS case number 22 of 2026 pending before the learned special judge NDPS Gwalpara.
within bracket Lakhipur PS 4/26. The petitioner is in custody since when was he arrested?
My lord,
8/1/2026. 8/1/2026. Relevant documents and list on
18 Mali.
19,
18 or 19, we need.
18.
I am applied.
Item number 22.
And copy received by non-APS.
Okay. Should we
Non-APS.
adjourn it for tomorrow? We'll fix.
Yeah, John, next week, or because some cases are fixed.
None appears on scan TCR has been received. Of
Well,
Tita Board PS
they've
case number
come.
174 of 25. Yes, they've come.
I think.
We'll take it, 20. No,
21.20.
no, this is 22.
21.
Oh, tomorrow, man. 21. 21 whole. 20. Therefore, 21. It is already over, man.
Yeah, I have also ticked it. We did it just now.
Yes, yes. Fine.
Just
It
now.
is.
It is over. Some confusion is there. You are for 22, not 22.
No, 21.
22, man. Adjournment.
Non-adjured, none appears. So, however, scan TCR is of Tita Board PS 174/25 is received. Let's keep it for Monday.
Yes.
11.
23.
Please, your
Yes.
lordship. Lordship, in this case, when a charge is submitted, my lord. TCR may be called for, my lord.
NDPS matter?
Yes.
NDPS matter. Learned counsel submits that in the meantime, as per their instructions, investigation is completed and has resulted in a charge sheet. in view of the same, call for the scan TCR of, do you have the special case?
DPS case number 41 of 2026, pending in the Court of Additional District and Session Judge FTC Sribhumi.
Additional session just FTC Sribhumi. Sribhumi PSK 17 of 26. Petitioner is in custody since 25/1/2026. Let us fix it on 21 May. Is it okay? 21 May.
Yes, madam.
52.
Please, your lordship. Last occasion, the learned counsel was
Your lordship, on the same issue, I found some judgments. One is a
Sir,
judgment
today
which
just
fell-
come on. That's all.
I've just placed the judgment, your lordship. One is the judgment of the Honorable Supreme Court, three-bench judgment comprising of the Honorable Chief Justice, Honorable Justice Maheshwari and Honorable Justice George Massey, wherein it affirmed the judgment of the Honorable Bombay High Court.
Hmm.
And the whole issue in the Bombay High Court, I've also provided the copy of the Bombay High Court. And the whole issue revolved around section 48
Hmm.
regarding the necessity of any form.
Oh, so that issue, no?
Yes.
Oh, 48 is.
The,
Forward.
in that particular judgment of the Honorable Bombay High Court, which was affirmed by the full bench of the Honorable Supreme Court, there it said that the mere communication itself satisfies the legislative intent of section 48.
Kasi
Form-
Reddy, no? This one.
Yes. Form or notice is not necessary. In fact, in Vihan Kumar also, it was discussed in that Bombay High Court judgment, a division bench of the Bombay High Court judgment.
Hmm.
Therein also it was discussed that mere communication satisfies the legislative intent of section 40.
Hmm.
If I may take your lordship to the Bombay High Court judgment at paragraph number 17 onwards, 17, 18, 19 and 20.
Amrina Matthew
Yes,
Fernandez.
Amelina Matthew Fernandez versus Redeem Arvind Goel. And it was affirmed, I also.
And this was affirmed in Kasi Reddy. I'll study it.
Not
Okay.
affirmed in Kasi Reddy, your lordship. Kasi Reddy also says in
Oh,
fact,
same thing, same thing.
same thing with regards to
17, 18.
satisfaction of section 48
Para 17 onwards.
in
Yes.
Bombay High Court judgment.
Yes.
In the Kasi Reddy judgment, it's paragraph number 18, 19, 27, 28, 36 and 37.
27, 28, 30.
36 and 37.
Okay.
These are my judgments, so lordship may sign accordingly.
I'll have to go through. Any submission?
Lordship, I have also bought a few citations. Authority of this honorable court, Lordship has passed this order. It is in case of bail application 3771 of 2025, Sri Sujoni Roshid versus Union of India, where your Lordship has gone through the entire discussions and properly, finally, the issue has been let down. And regarding that particular 48, Lordship has taken up in a manner where it was considered that 48 notice is very much important along with 47. That is the communication of the grounds of arrest not only has to be given to the accused, but at the same time to the relatives, friends or any known person in a manner which is understandable and in writing along with the mandatory compliance of 47. So 22(1), Article 22(1) to be completely satisfied and to uphold the spirit, the reading has to be very carefully because the supplementary judgment in Bihan Kumar by Justice Koteshwar Singh has pinpointedly pointed to the fact that it has to be in writing to the information also. Now, in this particular matter, Lordship, if Lordship peruse the case record, the arrest memo is there, 47 is also there. But in the 47, there is no mention of the ground of arrest. Basically, it is something like a summarized information, which we can take it as substantial compliance of that particular mandate. But 48 is not there, which is very important because of the fact that a number of judgments from this honorable court have been passed where it has come to the observation of this honorable court that 48 has to be complied in a manner strictly. So in number of already number of judgments I have already placed before your honor previously on the other occasion. Today I am going to place your lordship, one particular order where lordship has properly discussed, including Probir Prokastov, Pankaj Bansal, Bihan Kumar,
Your
and
lordship, may I be excused? I have a matter in court number 1, lordship. D. Bora, your lordship. Highly obliged, your lordship.
So, your lordship, regarding the fact that whatever the learned counsel from DRI has submitted and has placed it before the honorable court, now the evolution of this particular law after the passing of the Bihan Kumar, we can say that prospectively this has to be done. But if we go back also in Pankaj Bansal, there was an order for retrospective effect. Then if we go to the CRPC also, section 50, there was the thing, but there was the mandate was already there. So the fact why we are raising this particular contention, and it has to be taken in a very serious manner. Why? Because the officials, by coming up with their excuses and saying that since we have complied half, the half, if it is not also complied, substantial compliance is done. If 47 is given and the arrest memo is there with the signature, but it has to be proper. The law says that it has to be absolutely in compliance. So if there is no compliance,
There is no harm in complying.
yes, absolutely.
And thing is that some things, unless you of course, I have to decide this, but prima facie.
Yes.
But, some things, if you, it is better if it is the compliance there has to be, in clearer terms.
Yes, sir.
Otherwise, we'll keep, it will be a subject of more litigation.
Yes.
Whether how much compliance,
Yes.
whether that is substantial.
Yes,
compliance,
yes.
Whether
So,
or not.
yes, it will continue. And finally, it will become an exercise which will always go to the upper bench, and then
We are already
we have to always wait for that
overloaded.
particular point.
So, they have they have furnished the 47 notice reasonably okay.
Yes, it is. We
So
also
all they have to do is, just
absolutely,
reproduce.
because in
reproduce-
Mihir, Lordship, in Mihir Rajesh Shah,
I'll see that.
it is already stated, already it has been propounded that 2 hours prior to production. So ample time to them. Charge sheet has also been filed. So why they have not complied? And if that is the way, then they will again in the coming times, they will also again seek the same excuse.
But now the law is sufficiently crystallized.
Yes, mine.
Now I think we can insist on that.
Yes,
perhaps,
yes,
perhaps.
absolutely.
Anyway, to chamber. I'll have to study a bit. Go through.
Yes, yes. Obliged.
May I please, your lordship?
Next one, hello?
Yes.
My lord, this is a succeeded matter and evidence has already commenced, trial has already commenced.
Okay.
The FIR, your lordship will find at page number 12, my lord.
This matter, we have not yet gone through the scan. After the.
After some time?
Sometime, we'll go through, madam.
Obliged.
Five.
55.
His lordship, my senior is in different court. Kindly pass over the matter for.
Sometime. CBA man. What's you, madam? Miss Kumar. Okay then.
All right, after some time.
Status report. Okay. After some.
My lord, I am already in jail for 54, 56 days, my lord. Nothing.
That's okay.
I'm not
I
arguing on merit, my
I
lord.
remember. I remember.
All right.
Let madam come.
Bail hearing 25.
You ready?
Not received, my lord. On interim, my lord. Yeah. From Kachar. Yeah. Take some time.
So case diary as called for is not received. Issue reminder. The interim bail granted by the order dated 13/2 stands extended till the next date of listing. List on
25th, my lord. 25th time.
26.
May I please, my lord,
Mhm.
to item number 26. Item 26, the prayer for PRS bill application, lordship.
My lord, before my learned friend start, my lord, I have to submit one thing, my lord. This is a case of POXO, my lord.
Mm.
Whether my lord notice step has been taken or not, my lord, that has to be verified. my lord.
Yes,
Yeah.
correct. I have already taken steps, lordship.
Without getting
That
them on Monday, my lord.
Monday? Oh, I think Monday will be better, I think.
Yes, my lord.
Huh?
May-
11th?
11th, lordship. May I please, lordship. Lordship, at least interim prayer may be considered, lordship.
The interim will be,
For interim prayer also, my lord, preparedness of the information is necessary.
anyway, you fix it on this thing on Friday only. Sorry, not 11th, 8th. Mm, mm.
10th, lordship.
We'll see.
Three prayers.
That day we'll see, 2 days. only. December.
May I please, lord?
It was my only-
482 application also. We have
Yes.
taken steps, CD was called for. your lordship.
POXO matter.
POXO is there, but your lordship, the FIR name accused, he has already been arrested, your lordship, and he has been already granted bail, your lordship.
Here, service report is awaited, madam.
This also kindly take instructions.
This interim prayer, your lordship.
We
are not
can,
into interim,
we can
and
fix.
I'm not the FIR name accused, your lordship. Page 8, your lordship. The FIR, your lordship. Typed copy of the FIR, your lordship. Page 16, your lordship, is the order of the state court, your lordship.
So what do you say regarding the interim prayer? That's a gray area. That's all.
Yes, my lord, that is a gray area, my lord.
But he's neither named in the FIR nor any allegations made against him. We don't know. He may have assisted the taking away of the
Yes.
girl. That we don't know.
Is it, lordship, interim may be considered, your lordship.
Yes.
We have taken steps against it.
Is it child marriage also? No, only
No,
POXO.
no, no.
Only
six-
POXO 6.
6 is there.
Well, it's better to wait.
Not that very short date, but day after tomorrow.
Day after tomorrow you will take.
After.
Friday.
But this issue will continue to bother us, I'm
Yes.
telling you, till it is resolved.
It can be disposed of day after.
On Friday, your lordship.
The case diary is received, however, service report upon respondable to is awaited. The prosecution shall take instructions. Full stop. The learned counsel prays for an interim bail on the ground that the petitioner is not named in FIR. Nevertheless, the matter will be disposed, and I could not list the matter on 8/5.
Right.
Take the instruction. Case diary be retained.
27.
Ale.
Made, please, your lordship. But on earlier occasion, case diary was called for anticipatory bail application.
Someone
Yes, my lord, the CDO has also come and service is also complete, my lord. But nobody has appeared.
No, wakalat, no, somebody had appeared on the
Yes,
last day.
last occasion, someone had appeared.
And that going to file wakalat number shortly. But today, nobody is
Already.
there.
Because nothing is shown in the record also, my lord, regarding walkout number.
Yes. No name is reflected.
Yes. But lordship, 1 month before they said that they will file in Wakata.
Should we appoint an
Amicus, but otherwise it will be pending, my lord.
wakalat number is not filed, no? It was proposed to, and there might have been change of plan also. No? Instruction may not have come.
100 friend is there, my lord, if can be appointed for the amicus.
You can be, okay? Your good name, please. Priyanki Das. P. Das, Learned Counsel, is hereby appointed as amicus to represent the informant as none appears for the informant respond number 2, despite completion of service of notice. Full stop. The case diary has been received in the meantime. Necessary copies shall be furnished to the learned amicus. List on tomorrow.
Monday alone.
Monday,
11.
11.
Deeply aware.
30.
Copy would be furnished to you.
My lord, may kindly pass over for the
After some
typing.
time?
Yes, my lord. Oh, please, ma'am.
1.
Here also there's a question of notice. Now appears for the petitioner today. The case diary is received, right? However, case diary received full stop. The case diary be retained. Further, the prosecution shall take instructions regarding service of notice upon the respond number 2. Please do so. Let us fix it on 12, 13, 13.
32.
Same POXO. The same order will have. None appears also here today. Full stop. The case diary is same order like before. Take instructions and will let us fix it on the same day. 13, same day, same order.
33.
Wait, please, your lordship. This is an anticipatory bail application. Respondent number 2 has appeared, madam.
Yes.
Case diary is perhaps not available, but your lordship, there's a prayer for interim. My lordship will kindly come to page 9, my lord. My lord, admittedly, a romantic relationship between a 19-year-old boy and a 16-year-old girl, my lord.
That's the Lordship. I'm sorry. Item number 32. Actually, it is. Actually, I am here, but I could not.
Okay, no problem. We have first we'll record your name. I think we have given a date. The diary has not come.
My present may be recorded.
Okay, I'll record it. The diary has not come. Diary has come, but he'll take instructions regarding service of notice upon the info. LK Bora. Same problem. It was same problem. No? I'll give this. I'll record your name. P. Colita. Same. We have given same date, 13. 13 next week. He'll take instructions regarding service. The diary is here. Diary has come.
Time being at 8.
I'm sorry, Madam, there is another court. Madam, your lordship, kindly see one lady is facing Madam POXO along with other section. Book the page 11, annex 1.
Which I can. 8. Page 8.
Yes, page 11, my lord. Use question as well, you know. Huh? It's a charge sheet, my lord, please. Charge sheet, please.
Charge sheet, please.
Yes. Page 11 is there for you, madam.
Service is there. What's a new matter?
Motion states today, the first date.
But for the POXO, it does not apply in the case of lady, my lord, POXO, because your lordship can for the
Minor sister did not return.
simply, my lord, she may come at all, my lord, if maybe she might have abated something, my lord, that may be there. POXO does not come on.
There are a lot of allegations, so I think we'll have to give notice because the section of abatement may come. 17 may come against this person, but own sister-in-law.
It's own sister-in-law.
And this is the surprising part.
Yes, second.
Sister-in-law. But at this stage, I think learned senior counsel and the 482 call for the. Oh, it is charge sheeted case, right?
Yes, madam. Scan TCR.
Scan TCR of special POXO case number 14 of 26. Within bracket Bilasi Para 338 of 25 from the court of the learned special judge, additional session judge Bilasi Para, the district of Dhubri. Further steps of notice may be taken upon respond number 2, informant, like that manner. Please the matter
Any date?
next week. Suggest a date next week.
14th, my lord.
14.
Timing at 18.
Present.
Search bail application, my lord, he was arrested on 28/5/2025. And on that 346 days in custody. First, you will find the FIR at page 13, my lord.
You are for the informant?
I'm your lordship.
Amicus.
Amicus for the informant.
As amicus.
Page
Page 13, my lord.
13.
But charge sheet was laid on 36/2025, my lord. Charges were framed on 7/8, my lord. So far, my lord, out of 6 witnesses, my lord, 4 has been examined, including the victim and the informant, my lord. And to my instruction, my lord, last evidence had taken place on 25/9/2025. Thereafter, on 9th occasion, my lord, that witness has not turned up, my lord. And he is in custody for last 346 days, my lord. The remaining witness, my lord, at least the eyewitness, my lord, the grandmother is not examined, my lord, till.
But the victim has implicated, however,
My
in
lord,
her
implicated,
statement.
my lord. Some
Please.
say implicated.
Examined as PW2, my lord, she is implicated.
My lord.
And as part of my lord, report of, as part of evidence of PW4 doctor, my lord.
Some scratch on the chest.
Injuries part is also, my lord, clear from the evidence, my lord.
It says, my lord, some scratch on the chest, my lord. Otherwise,
My lord, only one witness is left, my lord. Since the my lord, scan copy, scan copy has not been received, my lord.
my lord,
It was already called for, my lord.
Lordship will also say, my lord, on last
There may be
9th
call for,
occasion, my lord, 9th occasion that witness did not turn up, my lord. I have the dates also, my lord. 19/25, 6/11/25, 3/12/25, 17/12/25, 30/12/25, 17/12/26, 10/3/26, and lastly on 17/4/26. This witness did not turn up, my lord.
The report may be called for, my lord, fixing a sort that.
Hmm?
That up-to-date status report may be called for, whether PW5 has been examined or not.
No, my lord. Lastly, on the 17/4, it was fixed, my lord. It did not come, my lord. And next date is on 13/5 for production of the accused, my lord. 13/5. Not for evidence.
The girl is very small, 11 years.
11 years.
And considering her deposition, my lord, as a PW2, my lord,
Mhm.
this is a case of, my lord, although my lord charges has been framed under section 10 of POXO, my lord. But this is a case of, my lord, either 4 or 6 of POXO
Mhm.
from her evidence of the victim.
It was charge has been framed under
10, my 10.
10. Okay. That will create problem otherwise if it is not. Right. heard the invoking 480. Oh, sorry, I thought, Madam, forgot to hear you. Make your submissions, please.
Lordship, page directly, I would like to take you page 18 of his petition, Your Lordship.
18.
Yes, sir.
Your Lordship, ground of arrest which has been clearly notified, Your Lordship, accused person is an FIR named accused, and moreover, during investigation process, Your Lordship, sufficient evidence has been collected against the accused, and recording the victim girl's statement under section 180 BNSS stated that she was sexually assaulted by the accused. The accused person may be absconded at that prior time, Your Lordship, and during interrogation, the accused person confessed his guilty before police, Your Lordship. That is the main reason, Your Lordship. And moreover, Your Lordship, in the bail objection, Your Lordship, it has clearly mentioned that the
You have filed a bail objection.
Your Lordship,
Also, bail, there.
Your Lordship, and moreover, Your Lordship, a child is below 12 years age, Your Lordship, and
Very
it is
Tender
clearly.
years.
And mark has significant, Your Lordship. Significant mark has been showed, Your Lordship, by medical officer, Your Lordship.
52 last bill. Copy.
Trial is almost completed and there are some implications. So
That is there, my lord.
And page
Only
13.
that alleged eyewitness, that grandmother, she has not come before the court, right?
Girl.
medical report, yes.
Yes, ma'am. The last portion, my lord. Certain finger nails,
Nails, nails,
Yeah.
scratches.
out here.
And support.
It supports, Your Lordship, to the FIR which I have given, Your Lordship, for the victim, Your Lordship, that is annexed as annexure
I'll come to you.
31.
Okay.
That is relevant.
Anyway, your reply. You want to make your submissions?
My lord, only my lord, I cannot deny that opinion by the
That's okay.
doctor. Yes,
So, length of detention.
the length of detention, 346 days, my lord. And last 9th October, my lord, this witness did not turn up. my lord.
ঠিক আছে heard RJ Bora
MP has a
P and P Das Miss P Das amicus curiae for response number 2 inform petitioner is seeking regular bail in connection with Bipuria PS case number 110 of 2025 which after completion of investigation resulted in a charge sheet and registered as special POCSO case number 124 of 25 and presently pending for at the stage of trial before the Court of the Learned Special Judge North Lakhimpur. It is submitted by the stated and submitted by the learned the petitioner side that the petitioner is in jail since 28/5/25 and the during the course of the trial the victim and informant has already been examined. Copies of the depositions have been annexed with the petition. As also copy of the medical report. Scanned TCR has been received. The prosecution opposing the bail submits that except one witness, almost all others have been examined and their implications have been revealed from the prosecution evidence. Thus, learned amicus curiae for the supporting the prosecution submits that the medical report also lends support to the allegations and the girl is of tender years, aged about 11 years. As for the materials, the accused at the time of the incident is stated to have been aged about 50 years. The learned counsel submits that for several dates the prosecution evidence have not progressed. I have perused the deposition of the alleged victim girl and also her statement before learned JMFC recorded during investigation. I have perused the medical report and the findings therein. Upon giving consideration to the matter, And also keeping in mind the incriminating materials and the tender age of the victim. And the fact that the trial has reached the fag end, full stop. Incident bail petition stands rejected at this stage. However, it is hoped that the learned trial court would do the needful to complete the remaining trial expeditiously. Full stop. Bail petition stands disposed of.
My lord, I am obliged.
And we had 30.
Look, this for time being, my lord, but the thing is that
Still-
I have sounded CD is not available. And another thing, my lord,
We have
this, today is the second date for calling of CD and CD has not been received. 33.
CD has come. No.
Case that is not received, my lord, today.
Then should we adjourn it today?
My lord, a very short date may be given so that CD may be available, my lord. From last 2 dates, CD is not
Let
available.
me see. Not
Well,
POCSO, no? It's
I'm
other-
sorry, my lord, in this case, search is submitted, my lord.
What is the allegation?
So 3032 and arms act, my lord.
Not murder, no?
Not murder.
Not murder, my lord.
These are all false allegations, my lord, only. These are only false allegations.
Can dispose it of them.
Yes, my lord.
Charge sheet has been submitted, my lord. Let them appear before a trial.
That is also there, but otherwise allow also, it can be allowed also, or they can approach the learned court below also.
My lord, if it is not, I mean, if charge sheet has been filed, maybe called for TCR.
Lordship may, for the time being, my lord, may peruse page number 20, my lord. That was the earlier rejection order of the trial court, my lord. Page number 20, last paragraph onwards. my lord.
Yes, my lord. It has been rejected by lower court. But
that's
if
it.
I go again, they will reject. I have to come here only, my lord. That's why, my lord. If it is not there, city may call for
You
TCR.
can call for the scan copy of the charge sheet.
Yes.
Scan copy of the charge sheet. Full stop. Third, so, learned counsel for the, and RJ Bora, learned additional TP. Full stop. Petitioner seeking anticipatory bail in connection with Athar Gandhi PS case number 10 of 2026. Section. The case was registered based on an FIR dated 28/1/2026. It's alleged that with regard to the missing of a mobile phone, which was subsequently recovered from the possession of accused number 3 of the FIR. The accused persons named in the FIR along with others came to the informant's house and threatened him. Subsequently, hit him on the head with the pistol and also fired bullets, the result of which his son ran away and saved his life. So, allegations are exaggerated according to you.
My lord, it is their allegations only, my lord, but I have not done anything, my lord. The thing is that there was, at morning time, my lord, there was one mahfil in masjid. And after that, my lord, they have alleged on accused number 3 that he has stolen a mobile phone. But he has not stolen. It was just a coincidence that he found that mobile. And he was insisted to get it back. But the informant's son, younger son, he started to make it a chaos, making a huge scene out of that. And then at evening time, we along with other persons who went there, we said said that it was just a friendly terms. We went there just to offer our prayers and to get celebrate. And why you have started doing this? And then my lord, younger son was not there at that time. Elder son, he started doing. And my lord, he was saying that I am carrying gun and bullets and everything. Then my lord, if I am carrying, why I will shot him with this? Means
Cartridges were
shot
recovered
him,
anyway.
my lord.
Some cartridges were recovered. Full stop. The case diary was called for, but the prosecution submits that in the meantime, investigation also stands completed and result stands completed, comma, resulting in a charge sheet. Full stop. We'll get only the charge sheet, scan copy of the charge sheet.
That will do, my lord.
Full stop. Call for the scan copy of the charge sheet submitted in Patharkandi PS case number 10/2026. Full stop. Further, in view of the completion of investigation, it is directed that in the interim, in the event of arrest of the petitioner, in connection with this case, they may be allowed to go on bail of 30,000, one security each. Subject to the conditions that should they record their statement? Must have been.
My objection may be recorded regarding interim, my lord. Magistrate case.
Subject to the condition that they shall be available for trial if one commences. I got to use this right. The learned additional PP objects to grant of bail at this stage. So let them operate. If there's any further investigation, it can be their statement can be recorded, however, even if the investigation is completed. They'll have to file a supplementary,
Sir, my lord, now, my lord,
I'll not
summon
direct.
will be issued, my lord.
I'll not direct.
The summon will be issued.
Cooperate with trial if one
Yes, yes,
comes.
ma'am.
This on last week of May.
Highly obliged, my lord, highly obliged.
25 months.
Okay, 25.
Highly obliged, my lord, highly.
53. Finding 53.
So
55. 55.
must be still busy. Should I hear your part or
Yes,
wait?
my part, my lord.
You want to be free then?
My lord. Lordship, kindly, my lord, see, my lord, I am already in jail for 56 days, my lord. And my lord, statutory period is, my lord, 60. And young man, my lord, allegation is that, my lord, he has, my lord, demanded 8,000 rupees, my lord, for he is a manager, loan manager of the bank, my lord. So that was the allegation, my lord. I am not going to, my lord, merit of the case. Your lordship, kindly see, he is a, my lord, just last year he married, my lord, and his wife is now advanced stage of pregnancy, my lord. That I have stated, my lord. So my submission before your lordship, my lord, without
So,
going to the merit, my
just
lord.
come.
My lord, she has come.
Don't worry. I thought that he wanted to do his part, and I was planning to hear you later. No problem.
So my lord, as your lordship knows, my lord, that the famous judgment of V.R. Krishna, the jail is, my lord, not the rule, my lord. Bail is the rule, my lord. That still prevail in, my lord. That is the judgment, my lord. That judgment still prevail, my lord, in 2024 also, my lord.
He's basically seeking bail on the ground of length of detention.
And also, my lord, he also, my lord, already suspended because of his long detention.
Deemed suspension.
So there is no question of tampering the record. And he is a permanent employee of the State Bank of India, my lord. There is also no such, my lord, chance of absconding, my lord. So that's why I am submitting, my lord. Only 4 days left. There is no such has been.
His wife is expecting.
Yes. Expecting, my lord. That is, I have last year he married, my lord, and I have stated in para 16. Your lordship kindly see. Para 13, my lord.
It was not yet up. My Aji CD and so status.
Then yes, can you just please.
Yes, I'm giving. Okay. We call it hearing.
Okay, ma'am.
Should I place this judgment? No, that's not required, my lord. That is V.I. Krishna judgment.
I
and
want
that-
to,
that I-
what was the name of the judgment? Every
That
time
is-
I
that is, my
keep
lord,
forgetting.
N.N. Ahluwalia. Yes, that is, my lord, state of Rajasthan versus Balachandan. That is-
Balachandan.
Balachandan. That is, my lord, that is V.I. Krishna,
Yeah,
very famous
Balachandan.
judgment. Jail is, my lord,
Balachandan is.
yes, bail basic rule is bail is basic rule and jail not
One of
jail.
that's a
And that is, my lord, till 2024, my lord, also there is judgment reflected in 2024.
original thinking. That is, it started first
My lord,
concept was
my lord, that concept, my lord.
Mm.
So that my submission, my lord.
May I please your lordship? This is a trap case. He is the loan manager.
Yeah.
Used to deal with the processing of the loan. During, at that point of time, while he is availing some bribe, he has been trapped. Now my concern is that your lordship, the charge sheet is going to be filed within a few days. So he may be directed to appear there and take a regular bail because the total record will be there, and on the basis of the merit, the honorable trial court may grant the bail. And this is the CD, your lordship, as called for. I have given the status report as well as the CDL.
He has a wife in a advanced stage of pregnancy, so that I think that aspect can be
As your lordship.
considered. Any case, 56 days is there, but of course, I mean, corruption is corruption, whatever it is.
My lord.
That's true.
Lordship has discretion.
But nothing-
I have nothing.
We must also
And young man, he
fight
has to,
against
still has to reform.
big corruption, not every corruption, but especially big corruption. But corruption is corruption, no doubt. Now have a look. What is that aspect? Can be seen at it.
Charge sheet is ready. It is
Yeah.
at the stage of approval of the higher authority, your lordship.
Yes, yes. Heard Learned Senior Counsel T.J. Mohanto, assisted by Y Media and your good name, please. And M. Kumari, and Retainer Counsel CBM. You write it like that, right? Retainer Counsel,
Retainer counsel.
assisted by your good name, Nam to Didipo. The CBI first. Invoking 483 BNSS, the petitioner seeking regular bail in connection with RC case number so and so, registered under 7 of the Prevention of Corruption Act.
Rested on 12/3.
The gist of the prosecution case is revealed from the FIR is that the accused petitioner allegedly, who is a bank employee of SBI, allegedly demanded some illegal gratification, and a trap proceeding was laid and he was caught. Full stop. The bribe money's question is stated to be rupees 8,000. The learned senior counsel submits that more than the merit of the case is containing about the length of detention, which is 56 days as on today, vis-a-vis the statutory period of 60 days. Another contention is that the petitioner has a young wife who is in an advanced stage of pregnancy, and has drawn my attention to the narration in para 13 of the bail petition. Full stop. It is submitted that pursuant to his arrest and detention, he is already under suspension, and there is no risk of tampering with records. The case diary, the prosecution submits that investigation has progressed and on the verge of completion and submission of final form. The case diary has been produced before this court. On considering the matter of the opinion that in view of the investigation nearing completion, and also the aspects regarding the wife of the petitioner, can be granted bail at this stage, subject to suitable conditions. In such view of the matter, allowed to go on bail of 50,000 with 1 surety of the like amount, the satisfaction of the CBI. It's not which one is there. Which one? CBI number 1, additional CBI code number 1. Was concerned learned.
I don't know.
Concerned
Charge sheet
learned.
is not yet
Yes.
fixed, so it is not.
Concerned learned court. Full stop. And subject to the following conditions.
Fine.
He shall cooperate with remaining investigation, shall not hamper or tamper with evidence. Full stop. Violation of the bill, right down.
Condition may kindly be given.
Huh?
Some conditions.
My lord,
Yes,
definitely.
conditions.
Definitely,
What
but
other
any
conditions
condition,
do you
my lord.
suggest? You shall not hamper or tamper with evidence. Because people do not abscond.
My lord.
We cannot know.
Yes, they are public servants. So
It is increasingly difficult for
My
most of us to
it
abscond.
will
All our
be
data is there.
difficulty for them.
difficult in NDPS case, my lord.
Hamper or tamper with evidence. Full stop.
Definitely.
And violation of it. Return the case there. This post. This post. After some time. Or next time, we'll fix it tomorrow.
Right, 34.
লিখিব লাগিব cause list none appears in last date also. None appears for the appellant. Stop. Original TCR. It appears that the TCR as called for has not yet been received from the learned trial court. Issue reminder for the case TCR. Issue reminder for the TCR. This is the matter after the whole matter, the 3 weeks. The date deeding. 29/5.
35.
Lordship, TCR was called for on the last occasion.
Yes, yes. TCR still not received, so
Yes,
we have
Lord.
to issue a reminder. Peruse the concerned office note, full stop. The TCR is not yet received, issue reminder for the same. Stop. This is the matter after 3 weeks on 29/5, same date. No? 29/5.
6.
Enforcement. Notice we need a no. Appearing.
Piano, we have respondent number 2.
You're for the?
Sir.
Yeah. Okay.
Senior is unable to because of his unwell.
No problem, but this is okay. Your file, no? The leave petition. Leave petition against acquittal from learned counsel. Your good name, please.
Lordship.
Appearing on behalf of the ED, the department. Footstop. Seeks an accommodation as the learned leading counsel who is standing counsel.
My senior is second.
The leading counsel is unwell. Your good name, please. appears on behalf of respondent number 2.
The retainer counsel from.
Retainer counsel for AD. When should we fix it? Next week?
After 2 weeks, Lordship, if possible.
Lease the matter. It's better to fix a date, I think, 2020 matter. So lease the matter after 2 weeks on 22/5, right? Friday.
Nice.
Yes, service about the responsibility is completely under. And teacher also received and they fix on 12 or 14 for admission column.
Hearing
12 or 14.
and TCR has been received.
Service completed. my lord.
Service complete.
Service complete.
My court's report.
Oh, no, it's in my court. And counsel for the petitioner and K. Boysa for an additional pay. As per office note, office note dated 19/3/2026. On the basis of office note dated so and so, full stop. Postal consignment report, the postal track consignment report indicates delivery of the item to the addressee on 20th February to 20 February. This none has appeared. However, none has appeared so far on behalf of the said respondent. She was the informant, probably.
Informant.
The scan PCR has already come.
She already married to another. As per my information, she has already married.
I see. Okay.
Earlier there is the appear there.
So we'll keep it 25 matter. So we'll keep it at the admission stage. Okay.
Next week, 12 or 14.
Place the matter in the admission column. It might have been admitted already. Let's see.
Only notice or this?
Only notice,
Notice.
not admitted.
Not admitted.
Admission column on the
16, 12 or 14.
well, it can be later also. It will be on 25. 25/5.
Publish.
40.
Lordship, Your Lordship, 2/5/26, service report upon response.
Is awaited. Okay. Good. Drawing attention to office note dated 22/5/2026. It is submitted that service report upon the private respondent is awaited. Full stop. However, scan TCR has been received. Stop. List the matter after 3 weeks on a date to be fixed by registry. Let them fix it.
Blessed.
41.
No, right. Yes.
We have filed in IL also.
Yeah.
So it's some substitute petitioner also.
Substitution.
Yes, sir.
Oh, I see.
Lordship, this is a matter of 2014 and also.
Oh, very long. Enact case.
Lordship, all the requirement, we have fulfilled all the fine which has been held by the non-SDGM Gwalpara and Session Court, Lordship. That was of rupees 1,50,000, and that
Mhm.
has been paid, Your Lordship.
Mhm.
We have complied with the judgment.
Mhm. But what remains then?
So only what remains is, Your Lordship, the judgment that was passed by the court that
Directed
directed to,
more amount.
sentence to undergo simple imprisonment
see,
for
I
a
see.
term of 1 year,
I
Lordship,
see. I see.
and also to pay a fine of rupees 1,50,000.
Mm.
And that has been complied.
Paid.
1,50,000 has been paid.
You have a decent case in your favor then anyway. So you substitute.
Yes, Your Lordship.
You substitute the person. Heard, Mr.
You breath, Your Lordship.
Learned counsel for the applicant who has filed the instant interlocutory application seeking substitution of the sole respondent Amarjyoti Rava by sole respondent Ramakanto Rava by Amarjyoti Rava. Full stop. On the ground that the said Ramakanto Rava expired on 27/5/2022. A copy of the death certificate has already also been annexed. It is also submitted that in the main matter, that is criminal revision filed against conviction and sentence under the NI Act upheld by the appellate court. The revision petitioners already paid the monetary compensation, but the learned courts below had also passed a sentence of imprisonment. In place of deceased respondent Ramakanta Rava, Amarjyoti Rava may be substituted. The petitioner shall submit a fresh copy of the post title.
Matter be held as a part.
No, not necessary, because we have not touched the main matter. Okay. So the I stands disposed of, but it will have priority because.
So concerning the year gap, Your Lordship, from until now.
Yes. No, we'll hear it on fix a date and hear it. But you have to issue notice.
Your Lordship.
You have to issue notice. Full stop. The steps of notice shall also be taken by speed post and oblique or dusty upon the newly implemented respondent in place of the deceased sole respondent. Full stop. Thereafter, we'll
Date may be fixed, Your Lordship.
fix a date. I'll fix.
42.
Wait a minute.
May I please? Okay. 42.
Matter has been settled also, no?
Yes, Your Honor, both the parties already settled the matter, Your Honor.
You could not undertake justice service.
Yes, Lordship, what service completed, my lord? We get a report, my lord.
Okay, no problem.
But I have 2 times I have went there, Your Honor. I have not able to serve the.
But this is normal
But
course.
this is through normal.
That is true, my lord. That is the police station. my
Okay.
lord.
Already they have settled the matter, Your
Okay.
Honor.
Here the matter one day, then you can fix it. It would be even better if she comes. She is not coming.
He has already.
Hmm.
Okay,
Mr. Das, huh?
Yes, Lord.
Mr. Your good name?
B. Das, Lord.
B. Das.
Yes.
Learned counsel for the petitioner, and K. Boyso, learned additional P. Post. As reflected in the previous order dated 33/2026, the scanned TCR has been received. Full stop. the prosecution submits that in the meantime, instructions have service is also complete upon the respond number 2/informant. It's a POXO case.
No, so my lord, because my lord, they used to use POXO, so they send it that, my lord. They thought that, my lord, it's a POXO, but in the, my lord, the internal pages, it is correct, my lord. I have gone through that, my lord. That may be kept as a part of record.
It is submitted by the learned counsel for the petitioner, has also reflected in the aforesaid order dated 33, that the petitioners, the informant and the petitioner have amicably settled the matter, and an affidavit has also been submitted. Annexure B also. So let's wait for a date,
Yes.
whether she comes or not, then we'll dispose it.
Thought that may be fixed.
No need to appoint amicus, I think. No need. Do you see?
Sorry, my lord. But otherwise, because my lord, here, my lord, if it is a case of settlement,
But she will
my
not
lord,
have
the
instruction.
amicus counsel can only do,
No,
my
he
lord,
cannot
not the
have,
amicus
she won't
or
have
the
instruction. But in where it is essential, like POXO, then it is,
Then-
has to be, otherwise so it cannot be.
Otherwise, her number is provided by the police, my lord.
Hmm.
That is the petitioner's, my lord, that is the respondent number 2.
If she comes, it will be help. Otherwise, still, even if she doesn't come, we'll try to dispose it.
That may be kept as a part of the record. my lord.
List the matter. It has been admitted. Matter has been admitted.
Yes, sir. Interim is there.
No, it's okay. But has it been admitted? Just check, huh?
512.
Notice only, I think.
Notice.
It appears that the matter has not yet been admitted and only notice was issued. Full stop. Therefore, the matter is admitted for hearing. Full stop. This is the matter in the admission column. On. (26.5). 26.5.
That's the lordship. Lordship, can you have a look on the last order 9/1/2026?
9/1.
26.
Oh, sorry. It was আগৰ order. Interim orders. The complaint case is at Mumbai.
Yes, my lord. For same cause of action, my lord, two different trial I'm facing. Here, my lord, in the Gauhati, I'm solely facing where they rest all together 167 accused persons facing in the Mumbai, my lord. And I made an application, this is application relying the section 204B as a 246, but Lanet additional says, my lord, has no discussion has been made on that point, my lord, and not consider a case, so I'm before this court right now. Specific thing, since all the accused persons, I mean, all the directors, all the concerned officials already made party 167 altogether in the metropolitan court.
In Bombay.
In there. But here only, my lord, affair laws against all the directors, all the accused persons, but charges filed against me is a very surprising, my lord. Can you have a look on the affair first, my lord?
Senior colleague, my lord, submitted, my lord. Here, my lord, as per the office note dated, my lord, 25/26, my lord. In earlier occasion, my lord, that is the CD part was not available along with the record, my lord. So that was called for, my lord, and my lord, memo is issued by the registry on, my lord, 25/2026, and that is awaited, my lord.
Next date for framing of charges fixed on, my lord, this 16th of May, my lord. Earlier true occasion remanded by this court, my lord.
Case recorded.
Since it is in Gauhati, my lord,
26 only, my lord.
the Gauhati CGM, my lord.
The case record has not been received. Not received.
Not received, my lord. So
And what about the service? Any private respondent is there?
No, my lord, no private respondents.
No, only prosecution.
Yes, my lord. And see the citizen Gauhati,
Oh,
my lord, two reminders made.
okay.
16th of May is a fix for charging payment. So I am praying consideration of my interim prayer, my lord. Let them produce record, my lord, till my lord.
You wanted to show me FIR
Yes, my lord. Lordship will find FIR at page 47.
47.
Yes, my lord. 45 starts and 47. No specific allegations against me, my lord. Lordship, due permission, I like to read, my lord.
Read.
I have the honor to report that Speak Asia, which is an online multinational marketing company and provides service among intending panelists against subscription. Speak Asia has two master franchises, namely Fitness Management and Allied Services, and number 2, Milot, Seamless Outsourcing. And one Sri Arunava Saha, that is present petitioner, so also became franchisee as SPA Associate. As per the rule, Speak Asia, by depositing respondent number 3 LLC in the account of the master franchise Return Management Allied Survey. According to the scheme of the Speak Asia, if any person joined the company as penalty, he has to pay 1,000 and to buy a so-and-so to 10,000 for survey of 52 weeks, and in return penalties would get 500 per survey of 52 weeks. The amount received by local franchisee, this is important, my lord. The amount received by the local franchisee has to send to master franchisee. And by this way, Speak Asia has collected so-and-so through SPA Associate and closed down its business without refunding the benefit to the penalist and local franchisee. I therefore request you to register a case against the directors and the officials of Speak Asia under proper section of law. This is directed to specific direction, my lord, to lodge a case against the directors and officials. Now, lordship will get very surprised, the search sheet, my lord, at page 54. Annexure 8, page 58, my lord. The type copy, original copy, I like 66 and 67. 58, my lord.
58.
The brief, yes, 58. 58 and 59, I will read, my lord. The brief of the case is that on 13/3/2015, a complainant lost the ejaha to the effect that the Speak Asia is an online multinational marketing company and provided service among the intending panelists among subscription. Speak Asia is to master. This is the fact recorded as per the affair. Now, findings, lordship will find at page 59 of the search. This is as it is in the affair, whatever it is given the affair, my lord. At page 59, there are findings of in the search sheet, my lord. This is annexure 2, fact of the case. During investigation, the involvement of the accused person are established, and the fact of his involvement is found as under, my lord. During investigation and from statement of all the witnesses, including the complainant and the scrutiny of the collected documents so far, it transpired that the accused Sri Arunava Saha in a premeditated fashion willfully managed to collect public money from different people in the name of so-and-so wrongful gain, my lord, thus indulging the misappropriation for the purpose of cheating. The under the above fact and circumstances and under evidence gathered by the prima facie case established against the arrested accused person Arunava Saha. Whereas I am the only simple franchisee, all the directors and all the officials, my lord, not even single whisper made in the search sheet, my lord, only against me this search sheet has been filed. Now lordship will find, my lord.
Complaint, where is the
Complaint at page 82, my lord.
Complaint was filed against 67 directors.
167 altogether accused person. And this is a complaint lodged by Serious Fraud Investigation Office, my lord, before the Metropolitan Magistrate, Mumbai. The lordship will find, my lord.
He is also named in the complaint.
Yes, my lord. Page number 89. 62 is I'm one of the accused, my lord. 62. SP Associate Arunava Saha. There. Page 89, my lord. And three more, my lord, the accused from Gauhati, they were made party in this affair, my lord, but Mumbai, this complaint, my lord, they were also made party. They also, the three accused persons also belong to this Gauhati, my lord. Now lordship will find the findings. Sorry, complaint at page 99. Page 99, paragraph 7, my lord. Only paragraph 7 I will read, my lord. That during the course of initial investigation, it was found that SAOL, that is, my lord, Speak Asia Online, a company incorporated with the Accounting and Corporate Regulating Authority in Singapore and operated through its own website, speakasiaonline.com, and invited public to become an online panelist, as if I'm also become a panelist, my lord. By paying the subscription to e-magazine, on became panelists, they would conduct surveys published on the website and would earn income on submission of survey. SAOL was not registered with the ROC in India, On scrutiny of the available document and evidence, the investigation team found that so-and-so had established its business activities in India through Mrs. Haran Ventures Private Limited, Singapore, so-and-so, SBP, and the master franchise development, Milord, Tulis Texec, and herein after not TTPL, and Mr. Scruton Management, which is in the affair name, it is named Milord. Mr. Scruton Management and Allied Service, herein the scams and AS, and Mr. Seamless Outsourcing LLP. This franchise is also named in the affair laws in Gauhati, Milord, who collected money from the public in the guise of subscription in appointing global distribution and distributes the collection or representative as a. My lord, in the metropolitan that complaint case, altogether 167 accused person. If I appeared there, I took bail there. Since, my lord, for one offense, why am I facing two trial, my lord? In this regard, my lord, I made an application, my lord, for discharge application, my lord, and specific ground I have taken for 204 and only 246, my lord. But none trial additional says open, not even single whisper made so far as my ground, the specific ground I have taken there, my lord. Lordship will find that my rejection order at page implain order at 132. On 2nd September 2025, this is author pass, my lord. Specifically, I have taken, my lord, in the learned trial court, my lord, in my discharge application, that in the ground number 7, my lord, that application, my lord, inadvertently, when I could not enclose, my lord, that application, discharge application, I have to submit, my lord. Give it to me. It will be the same. Good. The voluminous document, so we could not enclose, my lord. This is a petition, my lord. Ground page 6, ground number 7, my lord. Specifically, we have taken. Page 16, ground number 7.
The allegations are different. I'll come to the prosecution.
Yes.
The court has held, which is, this is page? Your
Page
ground
16, my lord, ground number 7.
16.
That
Ground number 7.
2044B BNSS provided offense or offenses committed by several persons in the course of same transaction are to be tried together. By vice of provision 246. And that therefore the instant case may not be tried in isolation, keeping in view the above provisions of law as well as the legal principle as enumerated by the Supreme Court in time to time. In this regard, I have also brought them to Honorable Apex Court decision, my lord. Since, my lord, cause of action, my lord, the offense is same, my lord, but here, my lord, one offense I'm facing here, and another for same offense, I'm also have to face in triangulator before the Mumbai, my lord. Why should I face
The
two trial, my
sections
lord?
are same.
Section, but interesting, my lord. Here, my lord, two more acts they have added here, my lord, in the affair, lordship will find.
Some of the sections are similar.
Yeah, my lord, in the
Price
Metropolitan
and
Court, all the sections level with the IPC, under IPC, my lord. But in Gauhati, my lord, only against me, my lord.
Section 5 of the Assam Protection of Interest or Depositors Act.
Yes, and section 13, sorry, my lord, what?
That can be a separate cause of action, perhaps. Assam Act. So that cannot be, applied in Gauhati, Bombay, by the Mumbai court, I think. Anyway, we'll come to that.
And my lord, section 5 2000 the Act 2013, the offense occurred in the July of 2011. This Act come in the 2013. Whether this Act is
That may not be
applied?
applicable.
Yes, absolutely.
Prima facie, anyway.
So the next day fixed on 16 for framing of charges. So I'm praying before the lordship, my lord, the protection in at this stage, let them come if case that all this case city, my lord. And lordship, the inquiry conducted by the Metropolitan Court with the voluminous document I like to place before this court and also my learned friend, my lord, what is the inquiry conducted by the Metropolitan Court, Bombay, with all details inquiry report. Lordship, I like to place this. Kindly. Detailed inquiry, my lord. Lordship will find all the allegations against all the accused persons, 167 accused persons there, my lord.
So inquiry done by?
It is done by, my lord, serious fraud investigation office, my lord. Enter report. And a specific page, lordship. Even, my lord, lordship will find in the inquiry report three three another Milord, accused persons are who belongs to this Gauhati Milord, but in the affair Milord, only they had direct to me Milord, and search sheet file against me only Milord. Why should I face trials? But I have same offense I am facing in a trial before the Metropolitan Code Section 13, sorry, Act 2013 is not attractive to me, Milord. And in the Metropolitan Code, the charges level against the IPC.
Anyway, this will take time otherwise.
Yes.
Anyway, should I proceed to
Yes.
the prosecution?
My lord, before coming to the, my lord, that is the facts and the merit of the case, my lord, may kindly pay.
Today we are actually, we're taking up mainly on the interim prayer, otherwise scan copy has been received.
My lord, may kindly peruse the order dated 25/3/2026, my lord, passed by this honorable court, my
Yes.
lord. My lord, may I read, my lord? My
Yes,
lord, last
content.
part, my lord. that is
Without
my-
the case diary, it has been
Yes,
received.
my lord, that is the, my lord,
Mhm.
difficulties.
Case
Because,
diary will
my
be
lord,
necessary,
here is
of
a case, my lord, what my limited understanding is that, my lord, this is a case, my lord, my lord, that is the economic offense, my lord,
Mhm.
where it is filed. Secondly, my lord, it is a, my lord, sit fund, my lord, as because,
Mm.
and in those cases, my lord,
Mm.
to find out the scene and the money trail, my lord, where, my lord, who has deposited, where it is deposited. It is a kind of nowadays, my lord, not only, my lord, that is because, my lord, they have another offices, multinational companies in Singapore and other places. In those cases, my lord, the money trail, my lord, the victim may be global, my lord. In case, my lord, a person from Guwahati, my lord, he may not aware about that is the money trail and the transaction, but he may be a victim of that, my lord. Now that things are going in a sane way, my lord. So at this stage, my lord, my humble prayer before your lordship is that, as because, my lord, as my learned senior colleague has submitted, that is the next date is fixed for, my lord, on 16, my lord, and it is from the Gauhati court. So, my lord, let a reminder be issued, my lord. Why, on the what basis, my lord? Because, my lord, there is one case, my lord, that is pending, my lord.
Case diary will be from the, it's
My
in the
lord,
court.
that is from the court, my lord.
Oh,
Because what I understand, my lord, that the
Scan
last
copy of the
order
case
was,
diary
my lord,
will
25/3/2026. But, my lord, from the registry, my lord, that is from the record, it is 2/5/26, my lord, it was issued. So maybe because of that, it is not come, my
Okay,
lord.
okay.
So, my lord, reminder may be given, a short date may be
Before that
provided
day of-
before 16, my lord, and then we will come, my lord, to the fact and to find out, my lord, what is there. But without going
interim,
through in those cases, my lord, where
interim will
complexities
continue
are
to be
there.
kept open. Interim prayer will be kept, continue to be kept open.
My lord, that
Till
may
then.
be open, my lord, because, my lord, if, my lord, there we find something there, my
He's
lord.
on bail at the moment. He's on bail.
Yes,
He's on bail.
yes.
So late, my lord, it will come, my lord. It
Anyway,
will not
we
affect,
can,
my lord, anybody.
16. In 16th, no, next date is, it cannot be 16. 16 is also Saturday.
Before that, my lord, any date may be fixed, my lord. Already, my lord, issue is sent, my lord, and next reminder may be given, my lord, in the next week, my lord. Any date before 16, my lord.
In this case, the petitioner is seeking quashing of the proceedings being PRC number 537 of 2020 on the ground that he's on the ground that on similar / identical allegations, he is also arraigned as accused number 62 in criminal complaint case number 5121/55/2015 before the court of the Metropolitan Magistrate at Mumbai. They submitted that in the instant case, the informant in the FIR sought an investigation against the directors and other employees of the concern. But after completion of investigation, only the petitioner came to be charged sheet. Full stop. The scan TCR has been received, but case diary has not been received. Full stop. From the learned court below. Issue a reminder to the court of the learned additional CGM, Kamrup M, for sending the scan copy of the case diary
Case diary,
pertaining to PRC number 537 of 2020. Give the case number, huh? PS case number. PS case number is BIEO. PS case number 9 of 2015. Full stop.
Pending before, my lord.
Additional CGM.
Additional.
It is submitted that next date is fixed on 16th this month for charge frame. The full stop. The petitioner is on bail. 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 The petitioner prayer for stay of the proceedings is kept open. We'll fix a date when, 13 or 14? 13. Okay. Would you like to take back this, Mr.
Lordship kindly keep it on record, matter of
No,
record.
this one.
Yes, yes, Lordship kindly may record me, Lord.
No, this I'll keep. This you can take back on the next day.
Since I have
Very
to submit,
voluminous.
so let me keep your record, my Lord.
Are you aware?
Deeply obliged, my Lord.
44.
Please, Manoj. The steps have been taken for service of respondent number 3 complainant, Manoj.
As per office note, my lord, no steps taken, my lord.
We've put the receipt of the speed post to.
You must have taken recently,
Yes, Manoj.
probably not reflected in the cause list. Sorry,
Receipt
the
has been
office
has
note.
been filed, my lord.
Huh?
The receipt has been filed otherwise, my lord. A speed
the
post to the officer.
Office note has to be updated then. 2-5. Fairly recent, but still must have taken after that. One and two you can represent, I think.
Only for 3, my lord.
For Mr.
SG Rumnong, RUMNONG.
And K. Bosso, learned additional PP for respond number 1 and 2. So steps of notice is stated to have been taken upon respond number 3. So office note dated 2/5/2026 has not been updated, it appears. Does not reflect it and not reflected, full stop. The office note may be updated and service report is awaited. We'll await service.
Please await it.
List the matter after 3 weeks. The date to be fixed by the registry. Any record to be called? Let us save time. In the meantime, call for some records or something.
A TCR has been called, my lord. Already. Must be on record.
It has been received. Scan record. The scan TCR has been received already.
45.
May I please, Lordship? Lordship, it's a condemnation
Delay?
delay of 111 days, Lordship. No, notice.
Here, my lord, service is awaited. They have taken the steps, my lord. Allow us some time, my lord. In the meantime, we will take the instruction, my lord, regarding the status of service of notice, my lord.
Delay condemnation, conviction, judgment of conviction.
Lordship, the POCSO case, Lordship. Convicted under section 10 of the POCSO.
Is he in custody? Is in custody. Okay, you take the instructions. No?
Yes, my lord, we take the instruction.
The prosecution shall take instructions regarding, you are appealing for legal aid counsel?
Lordship.
Learned legal aid counsel for the applicant appellant. The prosecution shall take instructions regarding service upon the respond number 2 informant on this with regard to the matter. List after 2 weeks.
Next week.
Next week, any date may be given.
Next
We'll
week.
take the instruction, my lord.
Next week.
And my lord, amicus may be appointed.
15.
15.
Obliged, Lordship.
46.
The appeal is already admitted for hearing and then TCR has been received. So today is fixed for consideration of IA in this case. And there is a fixed term of sentence imposed upon the appellant for 7 years. Already he has undergone more than 11 months of imprisonment.
So should we here appeal is 26, right?
2019 matter, my lord.
Huh?
2000, my lord, that is the judgment dated, my lord, that is the, my lord, 9/12/2025. So it's, my lord, it's an intermediate quantity. Only, my lord,
Appeal is new.
appeal is new, my lord. So my otherwise, my lord, TCR received, my lord. It's already received. My
We'll
lord.
fix because in terms of that judgment, suspension of sentence in an NDPS case also brings in 37.
My lord.
Brings in 37 as per
Allegation was, my
that
lord,
judgment.
my lord, intermediate quantity. My lord.
Harassing.
37 not applicable.
No, can you take up that judgment? Harassing.
Yes, my lord.
Harassing.
I-
Harassing?
Right now, I don't have.
No,
my
no.
lord,
What is the name of the judgment? Harassing. Exact paragraph I want to take it out. It says that for suspension of sentence in NDPS case also,
my lord.
the 37 would be applicable. But normally we know that it is applicable only to commercial quantity.
My lord.
But in case of this part, I have not understood fully.
Right.
This aspect I have
But
not
I will
fully
take-
understood
my-
that
I
whether
need some time.
37 is applicable to, because as you know, we had discussed once that there's a history of this
Right.
judgment actually. There was an amendment which said that no remission, no suspension of sentence in NDPS case. That was challenged.
Right.
Constitutional validity was challenged.
Right.
And the courts partly allowed the petition,
Right.
saying that remission still not there for
Right.
NDPS, like in terms of that amendment, and it was upheld in the no remission.
Right.
And secondly, with regard to said that you cannot take away completely the power of suspension of sentence of the court, appellate court. However, the suspension of sentence also has to be within the parameters of section 37. Huh? Dadu. I'm forgetting the name. Dadu versus State of Maharashtra.
My lord, yes, my lord, Dadu alias, my lord, Tulsidas versus State of Maharashtra. My
So
lord,
normally
paragraph
we
number
know.
is, my lord, 3, my lord.
Hmm?
Paragraph 3, my lord.
Normally we know na, that 37 is for commerce, but the thing is that will it now apply to every conviction?
Yes.
That part I have to
2008 SCC.
study and
437,
understand.
my lord. 2008 SCC, my lord. 437. 2000, my lord.
8 SCC.
8 SCC 437.
This part I need to
My lord, it is
study and
in
understand.
para 3, my lord. Substance is that, my lord, sentence under the act can be suspended by the appellate court only at the strictly subject to the conditions spelled out in section 37 of the act.
So going by the plain language, it seems to be applicable to everything.
Yes.
But normally people will not think like that na, unless they see this.
Yes.
The 37 we know is applicable only to specific sections.
My lord.
19, 19, 27A
Right.
and commercial quantity.
Right.
So convictions under commercial sentence, that's no problem. Understood. But for intermediate also now it will apply or what?
My lord.
Is it a constitutional bench judgment? So you kindly
My
you
lord, I will
can
bring that, my
guide
lord,
the
and
court.
also I need some time, my lord, go through the
Please,
PCR also. my lord.
you can guide
PCR,
the court
please.
on this. Because this will confront in many things,
My lord.
many suspension matters in NDPS,
My lord.
in intermediate quantity. Intermediate quantity.
So far as my limited experience, my lord, in Shapna Singho's case, she was sentenced to 2 years for in a small quantity. But she has been immediately her sentence suspended by this honorable court, wherein I have appeared. The appeal is still pending before this honorable.
But this aspect has to be,
Right.
discussed since it is there. That this is, which will not be applicable. Otherwise, that is why that it causes me some confusion.
So let this
This-
matter be taken up tomorrow.
Regarding my lord, commercial, my lord, that has to be considered, my lord.
No, but if it is a conviction of intermediate quantity, then
And my lord, as per of 9 of the judgment, my lord.
it's good if it can be, because otherwise 37 is only for the commercial quantity actually.
The section 32A does not in any way affect the periods, affect the powers of the authorities to grant parole. That was the case for parole actually, my lord. But it is unconstitutional to the extent that it takes away the right of the court to suspend the sentence.
It was taken away by the
They
amendment
convict, yes.
altogether.
Under the
No
act.
amendment and no remission, no suspension of sentence. Remission is still not there.
Third point, my lord, sentence under the act can be suspended
by the appellate court only and strictly subject to the condition spelled out in section 37 of the Act, my lord. In case of intermediate quantity, my lord, 37 will not come.
No, but here it does not say 37. It does not say only commercial quantity.
Yes, my lord, that, my lord, that condition is spelled out in section 37, my lord. 37 will come only in case of commercial quantity, my lord.
My lord, allow him some time, my lord.
So you're
my lord,
not
we will
wrong.
come with
Maybe
some,
you're
my
right.
lord.
If that is the reasoning, then it's good. That you're thinking like this, that your reasoning is this, that subject to 37. That means, in other words, subject to 37 and wherever 37 applies, as sir has said.
Then it cannot.
But we have to be a little sure, because otherwise you cannot end up violating a
I am only
judgment of
noted down
Supreme
the-
Court.
I have only noted down those 3 points, my lord.
Mm. And in any case, after a conviction is recorded by a trial court, how can you say that he's not guilty? Very strange. How can you even say that he is not guilty
So far as,
after a conviction is recorded? 37 is you have to reasonable grounds for believing that he's not guilty. That means the judgment is, in other words, you are saying that judgment is wrong, prima facie. Then you can perhaps. But you have already expressed a view on the judgment.
the judgment itself reflected that there are some lacunas and omission and material contradictions in the proceeding. Paragraph number.
Anyway, sir, let us let him take some time. And
Can it
this
be taken-
this matter we can take it parallelly. Yeah, it's a new matter. Otherwise, it will come down the list.
Can it be taken up tomorrow?
Oh, my lord, after tomorrow, my lord.
Tomorrow, let's give him some
My lord,
time.
Can it be Monday, my lord? Next week, my lord?
Yeah, you have some time. Study
Yes, my
this.
lord. In the
This is
meantime, I will put forward, my lord, all the,
this is
my lord,
one point in
precedents.
NDPS law.
Monday is 80 over.
This is one point in NDPS law
My lord.
where I have some confusion. I have
So
some
we will
doubts
go through that,
whether
my
it is this applicable. How plain language seems to be, like that. So maybe some other judgments we have to see.
Go through, my lord, then.
On 13,
Find
my
out
lord.
some authorities, my lord. 13, my lord.
The Paul Learned Council. The main appeal, you write, huh? Record has not come, no? Original TCR.
My lord, that is come, my lord. I tried to go.
Okay. The original TCR has been received from the Learned Trial Court. The appeal was admitted on 30/3/2026. Full stop. Paper book not necessary. Paper book becomes very convenient.
Actually,
but we
my
don't
lord,
want to burden
that
actually.
is always good, my lord.
Very convenient. Very
Otherwise,
convenient.
it is very difficult.
In
my
fact, I'm convinced that we should invest. Court should invest more in our
lord.
paper
Not that,
book
my lord, the
divisions.
10 years, my
In
lord.
our
Below
paper
10
book
years
divisions, we should
yes,
invest more. Writ
Yes.
appeals, criminal appeals, civil appeals,
That's
RSA,
true, my lord.
everything.
Justice is justice, my lord.
No, it's very good. And if you have any soft copy, you can study also. That councils can also. Anyway, so this is the matter.
11.
Main appeal. Main appeal will fix it
The
when.
order column, my lord.
List the matter
Or,
in
my
the.
lord, fix it for.
List the matter.
Or IA.
The orders column. After
11, May.
after what date you suggest? IA 209, the interlocutory application has been filed for suspension of sentence and bail pending adjudication of the criminal appeal filed against the judgment of the trial court, convicting and sentencing the applicant under the NDPS Act. Full stop. Original TCR has already been received in the appeal. Sorry, date 209 to disposed of. There's another I. No, main appeal. This is the matter in the orders column. You can suggest a date.
13th, my
13.
11th.
No, let it be.
12, 12.
Huh? No. 12/5.
Published.
Official date lordship is 2/5/2026. Service report is awaited.
Delay condonation.
Delay condonation.
The maintenance matter.
Maintenance.
The delay is. Yes. Mr. N. Ahmed, Learned Counsel for litigant. The IA is for condonation of a delay of 916 days. In preferring criminal revision against the judgment and order dated 12/5/23 passed by learned additional CJM. MR case number 26 of 21. Also, service report upon the sole respondent is awaited. We'll await
That lordship on 12.
after some more time. Give some more time. After 2 weeks.
On
After
14 lordship.
After 2 weeks.
14.
No, after 2 weeks, it will be best. Let's fix it on 20.
Plus.
20. Plus minus 20. Just one. Let me quickly, No, all right. Anyway, I can almost. Time being and admission. Service is not complete.
Malat, here, Malat, steps only taken on Malat 22nd of April.
No problem.
Wait service report.
The scan TCR has been received,
Received, Malat.
but service report is awaited with regard to respondent number 2. This is the matter after 2 weeks.
Malat. It may be fixed, we will take service report, Malat.
For 2 weeks will be a bit long, bail petition. The prosecution shall take instructions regarding service service upon the informant also. This is the matter on 14.
Malat, 14.
May please, your lordship. Lordship, parties compromise the matter outside the court.
They have compromised.
Lordship.
So you can take instructions and maybe also you're also appearing for this. They have compromised the matter.
I have no named instruction, my lord.
You take the instructions.
My lord.
If the parties have compromised, then it is pertaining to DV matter. So it can be withdrawn also. It can be withdrawn also. Full stop. Learned counsel, good name.
Pintas.
Learned counsel for the petitioner submits that in the meantime, the petitioner and the respondent have settled the matter outside court. However, Mr. Mullah, learned counsel for the respondent,
Hussain, my lord.
Huh?
M. Hussain, my lord.
Sorry, M. Hussain, learned counsel for the, I know, confused me. Learned counsel for the sole respondent submits that he has to take instructions regarding the same. First of the prayer is allowed. Full stop. Both the parties shall take further instructions regarding the aspect of settlement and make necessary submissions before this court. on the next.
My lord, he wants to withdraw, my lord, then
Ah.
I have no any
Then that is also, you take instructions whether you want to withdraw or not. If they can, if they want to withdraw, they can withdraw. We'll fix it after 2 weeks. After 2 weeks. Fix it on 21. 21/5.
Where the 13? In this case, my lord, you also need to see the last order dated 23/4/2026, my lord. As per, my lord, records were called for, my lord, scan copy, but that has been not received by this court, my lord. Scan copy is not there. I have seen the not sheet, my lord.
Okay. So we'll wait for something.
My lord.
It's a transfer petition and a criminal revision tied
My
together.
criminal revision and transfer petition, both are there.
Third start. Counsel for the petitioner, who has drawn attention to order dated 23/4/2026 and submits that the scan TCR as called for has not yet been received. Issue reminder for the scan TCR.
May I have a date, can make and fix, my lord?
I'll fix a date. Transfer
My
same order. Huh?
My lord,
Okay,
may
common
I
order.
present, my lord, 19/5,
You want it on 19/5?
my,
Fix on 19/5.
my favorite, your.
Well started.
19/5.
19/5.
14.
Please, your lordship, kindly pass over for time being.
That is after tomorrow, man.
You're for the petitioner.
Petitioner.
If it is something very simple, then we can take it up. Otherwise, on it. Why it has come up for today, Bora?
My lord, it is on the last occasion, amicus was appointed, my lord.
Amicus was appointed. Can we fix it tomorrow? Tomorrow we'll fix it.
Your lordship, the day after tomorrow.
Day after tomorrow. This is the matter on 8/5/2025.
Matter.
Yes. Quashing of FIR.
Second FIR.
Second FIR. Purportedly second FIR.
Yes, what we are saying that it is the, if your lordship, the first FIR. In the first FIR, if your lordship takes the petition at page 27. Please see page 27. Lordship got it fine. This is of 3rd of May 2025 on the right hand side. Lordship will kindly see the date and the FIR number.
Page two, I'm just coming.
27, my lord. You see page 27.
Hmm.
The first FIR, that's in the first column.
3/5/25.
Yes, 3/5, and FIR number is RC so and so 12. Kindly see 12. 12. Now, the sections your lordship noted, please, 61 to
PCX 7, 9, 10 and 12. Now the petitioner here is not named in the FIR. Now please mark, my lord, at serial number 5. Place of occurrence, Noida, UP and Dibrugarh SR. And if your lordship please turn to page 28. These are the accused. One, Priya Chakraborty is the Deputy General Manager, Oil India Limited. Please, this is the same person where there in the second FIR they have brought the second person also. I'll show it. Now, number 2, 3, 4 is United Drilling Tools Limited. 5 is unknown person. Now, we are not naming the FIR. Now, my lord, during the course, the 32 is the complaint. Please see 32 is the complaint. Now, please see paragraph 3. Source information also reveals that on 18/4/2025, see Jyoti Kumar Singh, that he was the accused number 3, my lord, to Priya Chakraborty, that was accused number 1. Your lordship, I have shown in FIR. That is at page, if your lordship sees at page 28, they are named. So this is accused number 1. That he has taken the approval of his managing director, Sri Kunal Gupta, for a bribe amount of 7 lakhs. Priya Chakraborty reminded him that he has not asked for cash and once again demanded delivery of 70 grams of gold coin instead. Jyoti Kumar Singh told him that due to some reason, he won't be able to purchase gold and therefore he would deliver rupees 7 lakhs in cash instead. Source information exit on 3/5/2025 evening, say Jyoti Kumar Singh would be delivering certain cash amount as bribe instead of gold to Priya Chakraborty near sector so and so, which also close to the resident of Priya Chakraborty Noida. The above mentioned act of the public servant and private person discloses the omission of cognizable offence under so and so against the Priya Chakraborty. Number 2 is my lord Kunal Gupta. Number 3 Jyoti Kumar. Number 4 is a company, United Drilling Tools. 5 is my lord 4. 5 is unknown person. Lordship got it, my lord. Now, this petitioner, before your lordship has to approve this honorable court in the first FIR. Why? Because my lord, at page 33, my lord, if your lordship looks at page 33, the police raided his house and residence. At page 33, my lord. And at his residence as well as his private office. Now, my lord will kindly please note down page 38. Please see page 38. When search was conducted in his office, at page 37 is the search list. Now, my lord will kindly see at page 38, 1, my lord. This is the contents, my lord. Please mark this. This is what I'll address. This is also a subject matter of the second FIR. Please mark at number 1, my lord. They recovered file GM tender so and so dated 17/6 so and so 190. This is the, my lord, at the office. This was raided, and I will show before this court that this is the second contents of the second FIR. Later they brought in their objection also. Now I approve this honorable court because there was an apprehension that I may be arrested in this case. So I came to this court. I lordship trouble this court by page 52. Please look into page 52. Page 52 is the first bail which was moved before this honorable court. Now, my lord will please see at page 53, 5, paragraph number 5. It is submitted annexer C is the search list, and while searching a file number, that's the file number which I have shown my page 38, dated 7/6/2000 was seized along with other articles. The search list also contains the detail of property which also includes one invoice dated so and so issued by so jewelry along with other articles. Now, my lord will see, please turn to page 55. This C55. Meanwhile, Lordship got it. Meanwhile, in the interim, at page 55, in the interim, in the event of his arrest, the petitioner Tushar Kasira shall be enlarged on bail of 50,000, be suitable. Petitioner shall appear before the IO within 1 week and cooperate with the investigation. Number 2, petitioner shall appear before the IO one every fortnight till completion of the investigation. All this was complied by the petitioner in the first FIR, and at page 56, there was a notice which was sent by the CBI under section 94 of the BNSS. These are the documents which they have sought for, and accordingly we complied at page 58. Please see 58, we complied. Now, and we cooperated with them. These are my flight detail because I have to fly from Tinsukia to Delhi. These are my flight tickets at page 59, at page 60. Now at 61, the matter again was listed because I was protected by interim bail at page 61. Now, before I read this, my lord, the absolute order which was made. Now, in this case, my lord, first FIR, there was an affidavit which was filed by the CBI. Objection, which was filed by CBI, which is relevant for the adjudication of the second FIR. Please see at page 64. Then I will show the absolute order. Page 64 is the objection that has been filed by the CBI in the first FIR. Please see at page 67, my lord, paragraph 7. Please mark this, my lord, which I will draw your lordship attention. That is the contents of the first FIR, second FIR. The interrogation of the accused, Vihar Chakraborty further revealed that he has received 2 gold chain from the petitioner Tushar Kesara, proprietor of Messer Industrial Traded Agency at Tinsukia on 12/4/2025 as illegal gratification for favoring the said firm in awarding a tender worth ₹3 crores for the supply of genset. He admitted to have processed the contract which was awarded during March 2025. The said 2 gold chains have also been recovered and seized. So this was the objection. One of the ground they have mentioned that in the first FIR, we have raided the house of Priya Chakraborty and we have found 2 gold chains which was recovered. And there his particular statement was that only on the basis of giving a contract. So far as genset is concerned, this gold chain is worth about 3 crores. So this is the contention which they've been made in the first FIR, objection. And they have recovered the file which contains of this file of 2 gold chains. Now, my lord will again try to trouble your lordship at page 61, how this bail was made absolute by this court. 26/8/2025. Please turn to next page, my lord. Page 62. See paragraph 63, my lord. Paragraph 3. It is submitted. The learned standing of CBI that charge sheet has already been submitted in this case, wherein the present petitioner has not made an accused, thereby indicating that no sufficient material has been found during the investigation against the present petitioner. So there was thorough investigation which they have made. Recovery of the gold chain will also, they recovered, and they also, Priya Chakraborty has said in respect of the contract which was given, these 2 gold chains. Now, kindly see, because they raised a point of maintainability, but paragraph 6, kindly see, having regard present development of the case culminating into submission of charge sheet without naming the present plaintiff as an accused, I do not consider it necessary to enter into question of maintainability. Accordingly, the interim pre-raised bail granted by it is hereby made absolute, subject to the following condition: 1, 2, 3, all this condition was given, and this was disposed of. That is the contents of the first FIR, which, my lord, I told, my submission is that second FIR now, your lordship, please look into the second FIR at page 43, which has been made to put to challenge at page 43. Now, please mark, my lord, page 43. One is, my lord, New Delhi, See the RC case number, it was original 12 at page 27, now it is 19. Dated is 18
At
8 page 43, my lord.
No, the second FIR.
Second FIR.
Oh, sorry. Different. Now it is 19.
Now it is
RT
19.
19.
Dated is 18 8 2025.
47, right?
Yes, correct. 43, my lord, page. 43.
Oh. 19.
19 and the dated is 18 8 2025. Now, my lord, will kindly see the place of occurrence has changed. The number 2 is same, section 61(2), PC Act is 7 9 10 12, same as the first FIR. Now, see the place of occurrence, they have changed 5. It is Tinsukia now, they made it. Tinsukia. Lordship got it, my lord?
Okay. In seconds. Okay.
My lord, at 1 o'clock. 1 o'clock now. Will you want to
continue?
Yeah, I will continue. There is no problem.
So we'll take it up at 2.
Yes.
No, you can complete the sentence which we said.
Yes. Now, my lord.
Otherwise, you'll look
Yes,
it up.
43, my lord. Tinsukia. Now, if you see at page 44, now, this was the first 6A. Suraj Rai, Inspector Suraj Pal, Inspector, same IO in the first FIR. Enter complaint. Now he 7, my lord. Please see at page 44.
Yes, sir.
Now see serial number 7.
Number 2.
2. He is the petitioner only. The accused, they have made an accused.
46.
Now 46 is the, my lord, the complaint. See the complaint. Now they narrated the same, my lord, is same copy and paste so far as the first 2 paragraph is concerned. If your lordship compares the first FIR, it is copy and paste so far as the first and second. I read the first, I not trouble again. The paragraph in that is 2012, 12, my lord. That is 3/5/2025, same. Gold chain, 7 lakhs, they are unable to pay it. That is a company, United Drilling Company. Same contents, my lord. Same, exact. Now see, my lord, last paragraph. Now of page 46. That during interrogation, the present independent witness Priya Chakraborty has revealed he has received 2 gold chain from Tushar Kesra on 12/4/2025 at Tinsukia's illegal gratification for favoring the firm, namely Messrs. Industrial Traders Agency, owned by Pradeep Kumar Kesra, against a tender worth ₹3 crores for supply of genset awarded so and so has processed the said contract. The said 2 gold chains has been recovered and seized by CBI on 3/5/2025 in presence of Priya Chakraborty, independent witness. That was the contents of the case which was registered on 3/5, and this particular was the only point where they lost the second FIR. Changing the place of occurrence, they said now they have changed to Tinsukia. Earlier it was Noida and Dibrugarh. Now subject matter of the first 2 paragraph is same. Third paragraph also this they want to bring up, which was a part of the first FIR itself. So this is the whole case, my lord. And if your lordship kindly see at page 47, again, 1 paragraph I'll read. Investigation revealed after the due approval of the competent authority, mobile numbers of so and so were intercepted. The recorded intercepted call conversion held between Priya's as well as other document collected during investigation has prima facie established Priya Chakraborty has demanded illegal gratification bribe from Tushar Kesara in lieu of tender number, same tender which they have recovered in the first FIR at page 38, my lord. That file is recovered, awarded to Industrial Traders Agency for supply and commissioning 3 numbers of so and so. Said Kusa has paid said illegal gratification price in form of 2 gold chains, which was recovered by them. So this is the contents of the FIR. Now, my lord, this I'll just 2 minutes, my lord. This what again we approach this honorable court by applying an anticipatory bail. Now, your lordship will see this. What is the page? Anticipated. Oh, my lord will kindly see my reply. Now, my reply, which I have annexed at 160. 160. Yes. 160 is the absolute order that has been part of the second FIR. Lordship got it? Second. And please see paragraph 3. It appears from record that one Priya Chakraborty was arrested in connection on allegation of accepting bribe from a contractor of Oil India. For interrogation, revealed that he received 2 gold chains from the on 12/4/2025 Tinsukia's illegal gratification, favoring the firm, namely so and so. Father of petitioner against a tender worth ₹3 crores, supply of genset award to said firm, which was processed. Accused Priya Chakraborty 2 gold chains has been recovered and seized by CBI on 3/5/2025. Said Priya Chakraborty, independent witness. Now, certain judgment was quoted, my lord. I'll just leave that, my lord. And page 166, please see 166, paragraph 17. See paragraph 17. As already stated here below, investigating agency has already recovered the 2 gold chain along with the voucher in question going by the material available on record. That is the only allegation in a petition that he has given, that said 2 gold chains are bribed to the accused in the return of official favor. Already learned counsel CBI has how much on the aspect of larger conspiracy is required to be unearthed. There is no, my lord, please mark, there is no such material available on record indicating any larger conspiracy beyond the single transaction between the petitioner and accused public servant referred to herein above, and which is the subject matter of the present FIR. Now, my lord will kindly see after discussion at page 167, they made the order absolute. After that, we approach this honorable court for questioning. On the ground, the second FIR should go because it is same contents you will see in the first FIR, where you, my lord, recovered one file which consists of 2 gold chains and their own objection in the first FIR. And thereafter, my lord, they said nothing was found against the present petitioner. That's why I was not named as an accused in the in the charge sheet also. So my whole contention is, my lord, boils down that how a second FIR, the contents of this is the same contents, is the same transaction, single transaction. So this is, my lord, facts part, my lord. They have filed an objection.
We'll take it up.
Yes, at 2, my lord. I'll show their objection, my lord, my reply and my judgments.
Got late.
Was reading the
The second FIR.
yes,
At
second
page
FIR I have
43.
read.
Yes.
So
Thank you.
I've read the second FIR, and your lordship, I have drawn the attention of the court to the interim bail which in the second FIR that was made absolute. The observation of the learned single judge was to the effect that one, there after perusing the material on record, the finding of the learned the judge was observed that it is a single transaction. It cannot be said to be a larger conspiracy. It is a single transaction, means it is related to first FIR, which connects a single transaction. Because what we have seen in the first FIR, one is that it is in relation to recovery that one Priya Chakraborty, that's a common man, Deputy General Manager of Oil India, where one of the contract, namely from United Drilling Company, he also sought 7 lakhs rupees, but he asked for 70 grams of gold coin. But that was, they said that it is not possible. So in lieu of getting a contract, 7 lakhs. In the same single transaction, again, when they raided the house of Priya Chakraborty, they found 2 gold chain, which is worth about 3 crores. And in the house, in the first FIR, they raided the office of the petitioner and they found 1 file. And that file is connected with a contract, which, my lord, where 2 gold chains were recovered. And for that purpose, a contract was given. So that is the contents. Now they have filed a second FIR. Now the contents of the first FIR and which they recovered and which they objection was filed is regarding the 2 gold chain which was recovered and a contract which is given to this petitioner. LS contract was given to this petitioner. Now, this is the contents and the observation of the learned single judge while making it absolute was very clear. On record, if your lordship looks into again, troubling your lordship at page 161 of the reply which I have filed, reply 160.
160.
Yes, 160.
is judgment.
Yes, is the judgment that was passed. 159. And please mark paragraph 3, my lord.
Of the
I'll
judgment.
not read, yes.
Judgment.
That is page 160 of the judgment. Maybe it is connection with an antecedent bail, which was made absolute, but the learned judge, the learned single judge has gone through the case diary of the second FIR. And what it reveals, my lord, at paragraph 3 and at paragraph 17 at page 166 is important. Please mark this, my lord. Although learned counsel for the CBI, after 4 paragraphs, at paragraph 17 at page 166, the order, as already stated herein above, the IA, the investigating agency has already recovered the 2 gold chain along with the voucher in question, and going by the material available on the record, that is the only allegation. Lordship got it? Only allegation against the petitioner. He has given the said 2 gold chain as bribe to the accused into official favor. Although learned counsel for CBI has heard much on the aspect of larger conspiracy, which is required to be unheard, there is no such material available on record indicating any larger conspiracy beyond, my lord, please, beyond the single transaction between the petitioner and accused, referred to here and above, and which is the subject matter of the present FIR.
Okay.
So that is the observation that has been made. Of course, that is an antecedent bail, man. Now, in their affidavit, please see their affidavit, what is the contents and what is their. Please see at page 78.
I'll come to that. You just go through it.
Yes.
Flip through. And in their reply submission, I'll.
Yes,
go
I'll
through it in
just
more
point
detail.
out.
Yes.
If you're
I'll make a note
please
of.
see 78. 78 pairwise reply at paragraph 9. Paragraph 9 at page 78. Please see, my lord, first, second, third, fourth, fifth, sixth, seventh. It is further stated that even if both of the FIR stem from similar circumstances.
Where? Page?
At page 78.
Para 9.
Para 9. Para 9.
Except.
It is stated that except the accused number 1, no other accused are same in both in the FIRs, even the transaction date and place of occurrence totally different. I'll pause for a moment, man. Please recollect the FIR of 2000, the RC 2012 of 3/5/2025, which categorically I have submitted that there is the accused name is not been mentioned there, unknown person. We came before, but Priya Chakraborty is a common person. What they want to say date and place of occurrence. Now date is 3/5. Place of occurrence, they have brought the jurisdiction Noida and Dibrugarh. Noida and Dibrugarh are totally different. Since public servant is one, and same does not mean that this is a second FIR when there are different offences, distinct transaction having different jurisdiction. It is further stated that even if both of the FIRs stem from similar circumstances, as long as the second FIR reveals new allegations or different dimension not covered by first FIR, it cannot be said to be barred in law. The present case, so and so, constitutes separate events, distinct transaction, different financial fraud and different criminal acts, cover a wider conspiracy of systematic corruption, and the petition declared to be rejected without any relief. There's their contention, my lord. Basically, they said that it is wider conspiracy, where lordship has marked that the learned single judge has observed that it cannot be larger conspiracy. It is a single transaction. single transaction which arises of the first FIR, where categorical statement in your objection you have made that we have recovered the two gold chains. Investigation, my lord, was completed. Priyat Chakraborty, when he was arrested in the first FIR on 3/5/2025, that these two gold chains were recovered. And these two gold chain is in respect of the alleged contract which was given to me. Because arising is in respect of some gen set, right? That's the
Yes.
so that is a single transaction arising out of that first FIR. Now please turn to page 82. Please see page 82. There are 17, my lord. I'll just read this. That in reply to the averment made in para number so and so, it is submitted during the investigation of RC number 12, knew that the first FIR, IO of the case has noticed some conspiracy between petitioner and Priyat Chakraborty, Deputy General Manager, Material Duliajan, All India Limited, Assam. Further, during the investigation of the matter, it is revealed that in another matter, Priyat Chakraborty accepted two gold chains from Tushar Kesera, so and so on 12/4/2025 at Tinsukia as illegal gratification favoring the firm, namely Industrial Trade Agency owned by Pradeep Kumar against a tender worth ₹3 crore for the supply of genset. That is the first contents of the affair where the file was recovered. Now please see. Hence, the person, place of occurrence and crime are different. It is an offshoot of so and so as the conspiracy case in 19 was revealed during the investigation of RC 12, but it can't be said replica of the previous case. That's the whole stand. Consequently, a separate FIR, RC so and so, was registered against the petitioner and so and so, so and so. My lord, basically that is their stand, which they have stated that here the person, place of occurrence, crime are different. But they have admitted is an offshoot of the first case, 2000, that is 3/5/2025, RC 12. What it reveals, because that investigation is completed. They recovered the gold chain because of the file that has been recovered from my office that pertains to a single transaction. So they can't say that we found that the person, place of occurrence, they changed the jurisdiction from Noida and Dibrugarh to Tinsukia. That's where Lordship will please find in the FIR of 3/5/2025, where the place of jurisdiction was shown as Noida and Dibrugarh. Subsequently, in the second FIR, they shown the place of jurisdiction Tinsukia. So they said that the place of occurrence is different. This is what they are trying. Now, they have written a lot of things in their affidavit. Please see, they want to T.T. Antony's case and Babubai's case, what they have stated in page 87. Please see page 87, Milo. Page 87. 8.4. In Babubhai Supra, it was observed that they quoted paragraph 21. In such a case, the court has to examine the facts and circumstances giving rise to both the affairs. And the test of sameness is to be applied to find out whether both the affairs relate to the same incident in respect of the same occurrence or are in regard to the incident which are two or more parts of the same transaction. If the answer is in the affirmative, the second FIR is liable to be quashed. However, in case the contrary is proved, where the version in the second FIR is different and they are in respect of the two different incident crimes, the second FIR is permissible. In case in respect of the same incident, the accused in the first FIR comes forward with a different version or counterclaim investigation, both the FIR has to be conducted. This is what they brought.
One of the principles.
Yes, the principle which has been laid down by the Supreme Court in Babubhai. And my lord T.T. Antony is also, they have mentioned in page 86, para 23. If your lordship please turn one page before that, 86, para 23.
Right.
23, they
Wow.
mention about TT Anthony. Your lordship has gone to TT Anthony's case. I don't want to trouble this court, but the
8.3,
principle.
they have reproduced the paragraph.
Yes, correct.
8.3.
Correct, madam. They have reproduced the paragraph.
Another
Yes.
decision. This decision, it was in Rathore. This was
Yes.
reproduced.
All they have reproduced, my lord.
See this.
Nirmal Singh Kahlon also, they reproduce the paragraph. How the Supreme Court held. This is basically a principle that has been laid down by the Supreme Court. And one has to test on the facts of the each case, my lord, the principle that has been brought. Now, we have replied, my lord, to their affidavit that has been filed. Our reply which,
I found it.
yes, which finds your lordship from 160, 132. Yes. 132 onwards, we have replied. And my lord will kindly see preliminary submission we have given. And genesis of the impugn affair at 133.
No.
Now, my lord, when, my lord, your lordship, please recollect, pausing for a moment here, my lord, when the first FIR was filed, your lordship recollect the observation that has been made by the learned single judge. What they said in their objection, they said about these two gold chains. And when the order was made absolute by the learned single judge, they produced a record saying that the charge sheet, I am not being named as in the charge sheet, in the first FIR. So they question about the maintainability. You have not been named in the charge sheet. Where is the question? What is the point? We were raising about your maintainability of the antecedent repayment. How this will lie? Because charge sheet your name doesn't reflect. Now, learned single just says that no, we are not going to maintainability. Your contents, the approach
Was decided
of,
on merits.
yes, this is what. Now, genesis of the impugn FIR, page 133, my lord. I don't want to trouble this. And the law. What is the law at page 134? We have also mentioned, my lord, what is the proposition, settled position of law that has been laid down Supreme Court in respect of the second FIR. All different judgment, my lord, we have mentioned. My lord, these are broad argument which has been made
Yes.
before this honorable court and certain judgment of the Supreme Court. Let my learned friend now argue the matter. My whole case, sum and substance of the case is that they could have filed a supplementary charge in the first FIR also.
Yes.
That didn't
that's what I was
prevent.
thinking.
It
That's
didn't
what
prevent.
that was I was thinking. That is not prevented.
That
In
is
the
not
course of
prevent.
investigation, another person is found.
Correct.
Obviously, that he can always be brought in.
Brought
By
in, yes.
subsequent investigation, by further investigation,
Yes.
subsequent charge sheet.
That's what my
But of course,
Investigation
if
subsequent.
it is a separate FIR, then it will have to pass these tests. Obviously, the test of these.
yes, correct, right, my lord. There was no bar for further investigation, putting a second supplementary charge in my lord. They could have done it because that was the contents of the first FIR when they recovered.
In a way, that would have been easier for them because
Correct.
otherwise you are facing this challenge, isn't it? Isn't it?
I'm
Anyway,
coming to the
any
merit of that.
if the CBI is convinced, then of course they can
I start.
they can go ahead. That's another matter.
May I please, your lordship.
Now we have to see.
My learned
Yeah.
friend very nicely
Yes.
has given the color of second FIR. And I have to pass that test. He has given me a big task.
No, I mean that's the thing.
Now
a
the
law.
question is, we have already given our reply, your lordship. So to start with, the question of second FIR, when there is a different transaction, distinct offense, parties are different. So in that event, when it reveals during the course of investigation, and the IO found it that it is out of different transaction and distinct offense, and place of occurrence is different. In that event, the IO is compelled to file separate charge sheet because the law mandate. How I am coming to that, your lordship? In the first, though it is not second charge sheet. I am not saying it is a second charge sheet
Yes.
for me.
a
For
separate case.
a separate charge sheet.
Separate case.
Separate case. Reason being, for the sake of convenience, because RC number are being in a big numbers, so I am taking the last number 12,
RC9, RC12.
that RC12 and RC19.
19.
19. One is, first one is not 12 and second one is 19. My objection, Lordship, may kindly be seen at page number 93.
93.
93.
Okay.
93. Actually, number is 12. These are the number, official number, and the year 2005. Number is, this is 12. Lordship, in the page number 94, it is written, 4 accused persons are there. First one is Prayas Chakravarti. He happened to be the common person, and definitely he will be common person because he is a public servant holding the post of DGM, and he is the in charge of material, and he is the only authority who is giving the tender, floating the tender and everything. Definitely he would be a common person in a company, so long he is not transferred. Now, second is Sri Kunal Gupta. He is a managing director of United Drill Tools. So here firm is involved. United Drilling Tools, your lordship. And who is the managing director? It is a Kunal Gupta and Jyoti Kumar Singh, DGM Sales Marketing, United Drilling and Tools Limited. So during the course of source information and interception, they have come to know, IO, that this person, Jyoti Kumar, Kunal Gupta, they are managing and trying to give a bribe money to Prayas Chakravarti in respect of their firm, United Drilling Tools, who has been given the work of, it is given, his work is not genset. It is a different, your lordship. That is at page number 105. 105 in our objection.
105.
In respect of tender number, last number 250. My learned friend has said that both the tenders are same.
Tender of number 250.
250 in paragraph number 16.22
I got
at
it.
page number 105.
I got it.
Never be same.
Tender, I didn't say same. I did say tender is the same.
Because I have marked, since you have.
No, I didn't say tender is same. How can be a tender be same? Tender has to be separate,
Anyway.
two different contracts.
Okay.
Anyway.
Yes.
So this is in respect of tender 250 last number and dated 1824, and this tender is submitted by United Drill Tools for supply and installation of commissioning of 2 numbers of truck mounted hydraulic wire line winch on 325. So in this case, this is a matter with regard to trap, and here it is a collusive trap. Because 2 persons are involved, collusive trap. Where the trap has been conducted, it is at Noida. Near the house of Prayas Chakravarti, he is having a residence at Noida. Admittedly, when the residence is Noida, trap has been conducted at Noida, the jurisdiction would be the UP, Ghaziabad, Special Judge, CBI.
Okay.
However, during the course of investigation, Tushar Kasera, his father is running his own company in the name and style of, your lordship, Industrial Trade Agency. Totally different. His father is running. So, he is also one of the vendor of the IOC, Indian Oil Corporation. So, during the course of investigation after trap, when the investigation was done, certain seizures are made. When certain seizures are made, certain documents have been collected from the house of the Tushar Kasera. So for the purpose of investigation, IO has every right for the purpose of investigation and to reveal the truth. He can go to anywhere for investigation. And being a citizen of India, it is the fundamental duty of a person, every person, to allow the police personnel for the purpose of investigation and cooperate also to reveal the truth. But in that FIR, Admittedly, no name appearing of Tushar Kasera, neither the name of the firm is appearing. Tushar Kasera Industrial Trade Agency. That is at page number 94, your lordship. However, thereafter, investigation, Tushar Kasera's house has been searched. He, apprehending his arrest, he has filed an anticipatory bail before this honorable court. On hearing both side, his anticipatory bail is allowed. However, CBI has made an objection that jurisdiction won't fall here in the Gauhati, because this is arising out of RC number 12, that is a trap. He is apprehending arrest, however, his name is not there, then even he has filed an anticipatory bail. After long hearing, he has been allowed bail. That is one part. Subsequently, what happened? During the course of investigation in RC 12, Prayas Chakravarti admitted that he has also received 2 gold chain from another vendor, another tenderer, that is a industrial trade agency run by father of the Tushar Kasera, and Tushar Kasera has given him 2 gold chain. In view of this revelation from the accused of 12, happened to be the common in both, being a public servant, IO has also started investigation. He has collected the papers, receipt and everything. And in view of this revelation, second FIR has to be filed. Reason being, because he was also given a tender, being an industrial trade agency in the same IOC, for favoring him for the installation of genset. That comes at page number 120. 120.
Yes.
120, this is RC 19, date is different. Maybe during the course of investigation, IO has come to know about this gold chain.
Page 120, right?
120.
Yeah.
This is a separate, totally separate, date is separate. Now I am coming to the next phase, your lordship, 121. Three accused, three names are there. Third one is unknown. However, Prayas Chakravarti, DGM manager, material, Tushar Kasera. His father is the owner of MS Industrial Trade Agency. So while comparing with 12, RC 12, this RC 19 is totally different, your lordship. Maybe public servant, maybe the common, because he is sitting in the authority. That is not the issue. In the PC Act, sections are common. Does it mean that the sections are common? That is not the issue.
No, the factual situation and circumstances. That is more important. That will determine.
Conclusive in nature. Another one is trap. This is a bribe giving for getting the favorable order, for passing of the bills. So I am coming to the content of 19.
This tender is for genset.
Genset.
And that tender was for?
That is for installation of some
machine.
Yes.
A machinery. Drilling machinery.
No, actually drilling machine, yes.
Something of that.
United.
Drills.
That is for another machines. It is reflected in the FIR itself.
This much.
Nature of work is totally different. Now I am coming to the tender number. Lordship, page number 105 of my objection. And page number 124 may kindly be read together, your lordship.
105 and 124.
124. Paragraph number 16.2.2. Investigation has revealed that a tender number JAM 2024B.
Wait, just okay. Read it, please. Go on.
Investigation has revealed that a tender number JAM /2024/B/52372250 dated 1/8/2024. This is in respect of this tender. Pertaining to whom? Jyoti Kumar Singh, drilling. His firm's name is I am coming to that, your lordship. His firm name is United Drilling, Noida. Situated at Noida, your lordship. Now, while going to 124, your lordship, paragraph number 1 to 3rd paragraph. In view of the above fact, and after the 3rd line,
Yes, got it.
the unknown person indulged in corrupt and illegal activity in allotment of tender number so and so. This is 502190 dated 7624.
No.
Amount is different. 2 crores, that is amount, that is near about 3 crores. To MS Industrial Trade Agency for supply and installation and commissioning of 3 number of 250 kVA gas engine driven silent acoustic generating set. Here, your lordship.
Yeah.
So here, both the parties are different. Cause of action is different. One is collusive, that is a trap. This is with regard to the giving of favoring this company while clearing the bill. If I will go in reading this content of this, that is from paragraph number 123, 2nd paragraph. Investigation on case number C12, New Delhi, has revealed that here IO has clarified it is not a copy paste. Situation circumstances where from 19 has arises, the IO has to explain, because they cannot create a case out of a thin air. Where from it is coming, that has been explained. It is not a patchwork, copy paste. It has been explained here. Lordship, I am coming to the page number 123, paragraph 2. Investigation of case number RC so and so 12, CBI AC 2, New Delhi, has revealed that Prayas Chakravarti has joined Oil India Corporation so and so recently, and Prayas Chakravarti has been working as so and so Dibrugarh since so and so. After completion of his deputation period in the directorate of so and so, and after his deputation, Prayas Chakravarti was assigned the work of table number 8 at a material department, Oil, Duliajan, Dibrugarh. However, by order dated so and so, he was assigned the work of table number 9 on transfer of Sri so and so purchase from material department to project department, Oil India, Oil Duliajan. Prayas Chakravarti was also suspended from the service on 4/5/25 passed after registration of this case against him. During the interrogation in presence of the independent witness, Prayas Chakravarti had revealed that he had received 2 gold chains from Tushar Kasera, son of Pradeep Kasera, on 12/4/25 at Tinsukia as illegal gratification for favoring the firm, namely MS Industrial Trade and Agency owned by Sri Pradeep Kasera, against the tender worth ₹3 crore for the supply of genset awarded to MS Industrial Trade Agency. Sri Prayas Chakravarti had processed the said contract. The said 2 gold chain had been recovered and seized by CBI on 3/5/25 in presence of Prayas Chakravarti and independent witness. Investigation has revealed, after the due approval of the competent authority, the mobile number of Sri Prayas Chakravarti and others were intercepted. The recorded interception call conversation held between the Prayas Chakravarti and Tushar Kasera, as well as other document collected during the investigation, has prima facie established that Prayas Chakravarti had demanded a illegal gratification bribe from Sri Tushar Kasera in lieu of tender number 900, last number I am reading, your lordship. Another one is 50.
Okay.
This is 900, dated 7/6/25 for ₹2 crore, some odd amount, that is 3 crores, awarded to MS Industrial Trade Agency for supply, installation and commissioning of 3 number of 250 kVA gas engine driven silently acoustic generating set. Sri Prayas Chakravarti was the purchase officer PO in the said tender. Sri Tushar Kasera had paid the said illegal gratification to Sri Prayas Chakravarti in form of 2 gold chain. In view of the above fact and circumstances, there are reason to believe that Sri Prayas Chakravarti, while working as a public servant in the capacity of Deputy General Manager, Material, Duliajan Oil India Limited, Duliajan, Tushar Kasera, son of Pradeep Kasera, unknown others, had indulged in corrupt and illegal activity in allotment of tender number 900 dated so and so for rupees 3 crores to MS Industrial Trade Agency supply installation commissioning of 3 number of so and so generating set which requires in-depth investigation. The commissioning and omission of their part prima facie constitute a commission of offence punishable under section so and so Bharatiya Nyaya Sanhita under section so and so. Hence, it is requested that regular case may please be registered for investigation. So from this, it has been revealed that Prayas Chakravarti is involved in other distinct offence for favoring a different tenderer, different vendor party. So this is arising out of 12. Now I am coming to 19, your lordship. 19. At page number 23.
Page number?
123.
Oh. Okay.
Here, my learned friend has said the paragraphs are same, one and the same. Definitely, this is a recital clause. The IO has to reflect, since he is going to register a different case, he will have to reflect the source information and why this has to be registered separately. So definitely para would be the same. And that is why these paragraphs are matching. However, here the tender number and the date and order is different. I'm coming to that, your paragraph number, from the beginning. A case number, RC number 12, Delhi, so and so, BNSS, so and so, source information against Prayas Chakravarti, deputy manager, so and so. During the investigation, a trap was laid. So 12 is relating to a trap. A trap was laid by
Which paragraph
CBI.
you're reading during the investigation?
This is 123.
No,
Paragraph,
I'm on 23 only.
23, fifth line.
And second para?
First para. To the superintendent and complaint is there. Page number 123, my objection. Your
Yes, yes, yes. To the
fourth line.
Oh, okay. During the trap proceeding.
Yes. Here, IO is trying to explain that in 12, there is a trap proceeding. And while during the course of trap proceeding and investigation thereon, it has come to the knowledge that Prayas Chakravarti has received 2 gold chain. That is what he is trying to explain here. Trap was led by CBI 3/5/2025. During the trap proceedings, Jyoti Kumar Singh, Deputy General Manager, United Drilling Tools and Sri Prayas Chakravarti were apprehended after delivery and acceptance of bribe of rupees 7 lakhs. The said bribe was paid to Prayas Chakravarti by Sri Jyoti Kumar Singh. He is not Tushar. He is Jyoti of a drilling house. Person, Jyoti Kumar Singh, as his company MS United Drilling Tools, was awarded a contract of winch machine. This is totally different. Winch machine by Oil India Limited, valuing rupees 13.73 crores. That was 3 crores. This is different. Investigation of case number 12, RC 12, New Delhi has revealed that Prayas Chakravarti has joined Oil India so and so. I am coming to the last part. After his deputation, Prayas Chakravarti has assigned the work and table of number 8 at the material department, Duliajan, Dibrugarh, by order dated so and so. He was assigned the work of table number 9 on transfer of Sri so and so from the material department to project department oil. So this reveals that his duty, he has been allotted this duty, and whenever work has to be allotted or tender has to be called for, he is calling. So he is the single person who is allotting the work, who is passing the bill, and he is floating the tender. Definitely his name will be common in different offenses. Now, during the interrogation in presence of the independent witness, Prayas Chakravarti had revealed that he had received 2 gold chain from Tushar Kasera on so and so at Tinsukia as illegal gratification for favoring MS Industrial Trade Agency owned by Pradeep Kasera against the tender. So definitely it would be common. The complaint, the recital clause of the complaint would be common by the IO, and IO, if the IO would be same, there is no bar that IO would be same or different. They can be the same. Investigation has revealed after due approval of the competent authority that the mobile number, this I have read in that also, this is common. In view of the above fact and circumstances, there are reason to believe that Prayas Chakravarti, while working as a public servant, so-and-so of Udulia Jan, and to Tushar Kasera, an unknown other, indulge in corrupt and illegal activity for allotment of tender. This is 900. And for drilling tools, that is 50. This is 900. Date is different. And this is pertaining to 3 crores MS Industrial Agency for supply and installation of so-and-so. So my humble submission before your lordship. Now it is clear, the firm is different, party is different, supplier is different, offense is different. That is trap, this is a bribe.
Okay.
And the place of occurrence for the purpose of trap is Noida. That cannot be Tinsukia. And here Tushar Kasera is residing at Tinsukia. That is why jurisdiction is Tinsukia and Assam. That cannot go to there. So this is a part of second FI. This is not second FIR. 19 is the part of larger conspiracy which has been revealed when the RC 12 has been registered. So it cannot be said as a second FIR. Is totally different, your lordship. Now I am coming to the charge sheet, your lordship. There is a telephonic interception.
Charge sheet in this case, right? Second case.
103.
Page 103.
103.
Charge sheet, yes.
This is the charge sheet. United
from
Drilling
99?
Tools. Yes, United Drilling Tools. First line. So this
Page 10.
page 103. This is the continuation part
Company
of.
is also prosecuted.
Yes, United Drilling Tools and Jyoti Kumar is also made accused. And the company has been also made accused. And if I am coming to your lordship 108, page number 108. Telephonic interception is also there. In between Jyoti and Prayas. Revealing at 108, your lordship. So out of this interception, the trap has been laid down. However, in Tushar Kasera, there is no trap. This reflects. If I will go by this, it will take another 1 hour, your lordship. That is why I am not going through.
Okay.
However, it is revealing everything. It is in Hindi. Shall I go through, your lordship?
No, I can read.
Yes. Now I am coming to 19, page number 120. That is in respect of
119.
C12.
119.
That is in 12.
Okay.
And now page number 20, this is RC 19.
Yes.
In our objection, we have annexed both the charge sheet for the convenience of the court. Page number 120, Annexure C.
Yes. This is the FIR.
This is FIR.
Charge sheet is.
Charge sheet is also there. Thereafter. This is 19. And page number 121 clearly reflects Prayas Chakravarti, Tushar Kasera.
That's okay. Let's see.
And the averments, first paragraph 2 may be the same. Reason being, IO is explaining the source of registration of this FIR. And that is required to be, because out of thin air, they cannot create one FIR. Now I am coming to with regard to the. So this portion is, my learned friend had said, both tenders are same. It is not same, which I have already clarified. Firms is same. Firms are not same. Totally different. Date is different. Date is also not different. Tender, NIT, all are different. Work order is different. Because it is relating to different firm. and there is no single and same transaction. And it cannot be, your lordship. Admittedly, that is trap, and this is.
Yes, you have said.
So, question of single transaction does not arise at all. Trap is a collusive trap. However, with regard to the observation made in the bail application, your lordship, my learned friend said that in the bail application, his bail application has been made absolute, and on the same ground that it is a second FIR or whatever. However, in this regard, bail application is never based on the merit of the case.
Some aspects.
To some extent. However, since bail is right, so he is also, bail is a conditions are imposed, and he is asked to cooperate with the IO, and he is also asked to not to tamper with the witnesses. Reason being, Honorable Court knows that trial would be there. Had there would be a no trial, question of giving any condition does not arise. Had it been taken that observation is that there is a no prima facie case, does it mean that it will quash total charge sheet? It cannot, any observation of the bail cannot quash total charge sheet. Otherwise, no question of filing this criminal application, this criminal revision petition. If that observation is, can have any effect on this charge sheet. That is why conditions are being given not to tamper, cooperate with the IO, face the trial. That is most important. So any observation given in the bail cannot be taken in the merit of the case, your lordship, at any point of time. Yes, now, had there been a single transaction, it would have been a supplementary charge sheet. Why IO cannot able to file a supplementary charge sheet? Otherwise, in RC12, IO could have filed a supplementary charge sheet. Reason behind is that when he has gone for investigation, he has found different firm, different person, place is different, cause of action is different, NIT is different, vendor is different. So from any remotely also, it cannot be linked with RC12. 19 cannot be linked with RC12, even remotely. So the color which has been given for second FIR from prima facie, it cannot be said to be a separate second FIR. Prima facie, it is a different, in fact. Plain reading will reveal that it is a different FIR. And relating to the economic offenses, which has been in number of cases treated as heinous crime. I am coming to the judgment, your lordship. I won't take much time in the merit of the case, since 2 FIR is very much there in my objection. I have annexed for the sake of convenience. Now I am coming to the, with regard to my learned friend has given a TT Antony, which has been already distinguished in Anuj Chaudhary, your lordship, and they have also relied Anuj Chaudhary. But Anuj Chaudhary has clarified with regard to the second FIR and first FIR very clearly. I am coming to that, your lordship. This is also division bench, your lordship, Supreme Court judgment. And it explained with regard to the TT Antony's case. Para 40, page 404. Last paragraph. This court in Kari Chaudhary versus Sita Devi discussed aspect of law held in so-and-so. The learned court adopted an alternative condition that once the proceeding...
Just a minute, madam. We are on. Let us be on the same page.
404,
404, right?
404.
Okay. So para 21?
18. It is the, otherwise para 21.
Yeah, actually it's part of para 21. This code, yes, got it. Sorry.
The learned counsel adopted an alternative condition that once the proceeding initiated under FIR number 135 ended in a final report, the police had no authority to register a second FIR and number it as a FIR number 208. Of course, the legal position is that there cannot be a two FIR against the same accused in respect of the same case. But when there are rival versions in respect of the same episode, they would normally take the shape of two different FIR and investigation can be carried on under both of them by the same investigating agency. So here a question mark has been given that the IO is same. Definitely the IO would be same because the investigating agency would be the same. Now I am coming to, instead of going further, 23. Next, be that it may, if the law laid down by this court in TT Antony case is to be accepted as holding that the second complaint in regard to the same incident filed as a counter complaint is prohibited under code. This is with regard to the counter code. Then in our opinion, such conclusion would be lead to a serious consequences. This will be clear from the hypothetical example given here in below. That is, if in regard to a crime committed by the real accused, he takes the first opportunity to lodge a false complaint and the same is registered by a jurisdiction of police, then the aggrieved victim of such crime will be precluded from lodging a complaint giving his version of the incident in question. Consequently, he will be deprived of his legitimate right to bring the real accused in book. This cannot be purport of the code. Thereby it is, we have already noticed that TT Antony's case, this court did not consider the legal right of an aggrieved person to file a counterclaim. On the contrary, for the observation found in the said judgment, it clearly indicates the filing of counterclaim is permissible. This is TT Antony is only with regard to the counterclaim, which has been clarified here. Now I am coming to the 405, your lords. 405. No. 407. A. A, from starting from
Yeah.
a small. One or more than one cognizable offense cannot be ruled out. Other material and information given to or received otherwise by the investigating officer would be a statement covered under section 162 of the code. The court, in order to examine the impact of one or more FIR, has to rationalize the fact and circumstances of each case and then apply the test of sameness to find out whether both FIRs relate to the same incident and to the same occurrence are in regard to the incident which are two or more part of the same transaction or related completely to two distinct occurrences. If the answer fall in the first category, the second FIR may be liable to be quashed. However, in the case the contrary is proved, whether the version of the second FIR is different and they are in respect of two different incident and crime. It is very much clearly distinguished here, Anthony. Two different incident and crime. The second FIR is permissible. This is the view expressed by the court of Babu Bhai, state of Gujarat. They have also relied Babu Bhai. I am also relying on that. Babu Bhai versus Gujarat. This judgment
It's one of the leading cases on this subject of law.
And
TT Antony, Babu Bhai.
Has distinguished TT Antony, Babu Bhai, and everything. And it is coming out. Antony's was first one. Thereafter this Anuj. Anuj has relied again Babu Bhai. So Babu Bhai, state of Gujarat, this judgment clearly spell out the distinction between two FIR relating to the same incident and two FIR relating to the different incident. Our is different incident or occurrence of the same incident, etc. And now I am coming to paragraph number 29 at page number 408. Even the offenses which are stated to have been committed and for which the two FIR were registered in these respective cases were different and distinct in the complaint filed by the Parvez which was registered as a FIR, name of the person were mentioned, and general investigation was called for, while FIR 145/2007 registered by Hazrat was against unknown person for damage of property so and so, which was a specific offense without any other complaint or allegation or any communal instigation or right. In other words, these were two different FIR relatable to two different occurrence. Investigation of one was no way dependent upon the other, and they are neither interlinked nor interdependent. They were lodged by different person in relation to a occurrence which are allegedly to have occurred at a different point of time against different people and for different offenses. And therefore, this petition was dismissed by the Honorable Supreme Court. Babu Bhai is also there.
Okay. I can take a copy if you have a spare copy.
Yes, I can give you. I have brought all the spare copies. Page 262.
262.
It has explained with regard to the Ramlal Narang. And I have brought also the Ramlal Narang also. Two FIRs. Ramlal Narang. This court considered a case wherein two FIR has been lodged. The first one form a part of the subsequent larger conspiracy, which came to light on receipt of a fresh information. Some of conspirators were common in both the FIR, and the object of conspiracy in both the cases was not the same. It is very clear, not the same. The court, while considering the question as to whether the investigation and further proceeding on the basis of both the FIR was permissible, held that no straitjacket formula can be laid down in this regard. The only test whether two FIR can be permitted to exist was whether two conspiracies were identical or not. After considering the fact of the said case, the court come to the conclusion that both conspiracies were not identical. Therefore, lodging of two FIR was held to be a permissible. So this is paragraph 19 is also making it clear at page number 264, Your Lordship. Last paragraph 67. The second FIR, in our opinion, would be maintainable not only because there are different versions, but when new discovery is made on factual foundations. Discovery may be made by a police authority at the subsequent stage. Discovery about a larger conspiracy can also surface another proceeding. As for example, in the case of this nature, if the police authority did not make a fair investigation and left out conspiracy aspect of the matter from the purview of its investigation, in our opinion, as and when the same surfaced, it was open to the state or the high court to direct investigation in respect of an offense which is distinct, separate from one for which the FIR had already been lodged.
Right.
This is Babu Bhai. Babu Bhai is also relied in the Anuj, Your Lordship. And in Anuj, T.T. Antony has distinguished. So in fact, all these judgments are interlinked, Your Lordship.
Interlinked. It's a
Sequence
development of a law.
Yes, and that has been made concrete by one by another.
The earliest one is T.T. Antony.
T.T. Antony. And that has been distinguished.
Developed.
Babu Bhai and Anuj is relying, Babu Bhai is
Kalon is this.
Yes, Your Lordship. And all are the division bench.
Two judges. Supreme Court is all division bench minimum.
There are so many. That is with regard to the mini trial that this court cannot do the mini trial for quashing purpose. So for quashing, I have 10 judgments, Your Lordship. And for this second FIR, I am having.
Quashing principles not necessary.
Not necessary. So I am confine myself to the
These would be
second
necessary because this is the issue at hand.
issue.
Issue at hand, right?
Another one is
Yeah,
whether it is
do you have TT Anthony? You,
it will verify or nothing.
otherwise it's okay, no problem.
Or I will provide you.
No, it's okay, no problem. I'll take it off. Only relevant paragraphs. These two I'm keeping, huh? These two I'm keeping. Anu Chaudhary, Anju Chaudhary, and Babu Bhai.
Provide.
No, it's okay.
And another one is whether it is permissible to file separate charge sheet for distinct offense on the basis of same FIR. That is also there. FIR
Same
can be
FIR.
one and the same.
But charge sheet is different.
Yes. I have that one also. Because charge sheet cannot be the, sorry, FIR cannot be the encyclopedia. Supreme Court has already said that FIR
first
cannot be
information.
the encyclopedia. This is just to initiate the machinery of the state. It starts from your lordship, paragraph number 23. From last page.
This is the Allahabad High Court.
Yes. High Court has also taken the view. Several High Court has taken the view of these cases. It is from paragraph number 23. It has also
But
been
usually from one FIR, I have not seen actually, but I didn't know this. It's permissible. I have not seen, however, from one FIR to charge sheets,
But
because
it's
different
fine.
sections all kinds of different sections can be given in a charge sheet, right? Much beyond, I mean, plus minus in different sections, different acts also.
But sometimes when your lordship in one FIR, when there is a larger conspiracy and out of the same FIR, some distinct offense, distinct transaction, distinct cause of action arose.
In
At that point of
to see
time,
this.
at that point of time, charge sheet has to be separated.
The Allahabad High Court has said it's permissible. Anyway, I'll see. That's all.
At that point of
Distinct thing.
time, charge sheet has to be separated.
I'll see this. Oh,
And I have one Surendra, they have also relied Surendra Kumar. Largest conspiracy, second FIR.
Actually, I did not rely any judgment as on date.
no,
I have
you
not
referred
opened.
to.
I have not opened also.
No,
a
no,
judgment.
In your reply.
You have referred to
Yes,
some of the judgments cited by them in
Yes,
their
I
object.
said I didn't give any
They
reply.
have cited.
Yes.
In the reply, I have not said, but in the reply it is cited.
It's okay. We just want the, the position of law on the subject.
That's
Actually,
not
there are hundreds and thousands of judgments nowadays.
But that will be never ending.
Yeah,
You
that's
just
what
give it. Principle of law has been laid down by
Otherwise,
Supreme Court.
we are,
And the facts has to be connected
there's so
with
much
our
of
case.
information nowadays in the world that we have to
Yes,
be
right.
careful about information overload also.
Well,
It will confuse us. Otherwise, on the point specific.
That is why I have given a sequentially after Antony, how many judgments are there?
This is a recent judgment.
You have to
Surendra
do it
Rathore.
like this is
Oh, this you had mentioned, I think. You had mentioned in your objection.
Yes.
Senior counsel had referred to this thing. Okay, no problem. I'll take
And
this.
this state of Rajasthan versus Surendra Singh Rathore. Just now I have given your lordship. Paragraph number 5. Eight one. Again, here it is referred Anuj Chaudhary.
Yes.
Just now I have given Anuj Chaudhary.
All these are discussed.
Paragraph number 8. Anuj Chaudhary, state of UP. So I have already given your lordship.
This has
Anuj
all the
Chaudhary,
previous
so
judgments.
I don't need to just.
This has all the previous
Yes,
judgments.
yes. Just to support my contention, I have given.
I get it.
And thereafter, your lordship, Kari
study all
Chaudhary.
this.
Kari Chaudhary is also explained there in paragraph number 8.2. Here also detailed here. And this is in this Surendra Singh Rathore, all the judgments are explained. Paragraph number 8.2, Kari Chaudhary Sita Devi, that has been given in the Anuj. Again, Upkar Singh versus Ved Prakash, your lordship. And then again 8.4, Babu Bhai. Last but one page, your lordship, Babu Bhai,
Yes.
8.4.
8.4.
Yes. So which I have already given your lordship, so I am not going to read this. And thereafter, the most important is 8.5, Nirmal Singh
Alone.
Hello. Discovery may be made by the police authority at the subsequent stage. Discovery about the largest conspiracy can also surface in another proceeding, as for example, in a case of this nature, if the police authorities did not make a fair investigation and left out the conspiracy aspect of the matter from the purview of its investigation, in our opinion, as and when the same surfaced, it was open to the state and the High Court to direct the investigation in respect of the offences, which is distinct and separate from the one for which the FIR had already been lodged. Very clear, Your Lordship. So my humble submission, their petition is not maintainable in view of the catena of cases. Time to time, the Supreme Court has clarified the thing right from the Antony, then Babu Bhai, Anuj Chaudhary, and Kari. So at this stage, their petition is not maintainable, Your Lordship. And looking to the both the FIR, both the RCs, that is RC 12 and RC 19. It's totally
Petition is maintainable, but on the merits.
on the
Merits of the petition. Okay. Good enough.
I'll just give a reply, my learned friend has finished 2 minutes reply, I want to give it
No
reply.
problem.
I'll just give 2 minutes reply. All the judgment that has been played, I don't deny all those judgments. These are the principle that has been laid down. Now the case coming back to our case, whether those judgment can be fitted in those particular, in those judgment, the principle.
What is this? A test of similarity.
Test of similarity.
We have to decide.
Now, two things
the
which
picture.
my learned friend had read Babu Bhai. Your Lordship has noted down certain paragraph in Babu Bhai where they said it has to be new discovery. New discovery and larger conspiracy. What is a new discovery? I am asking myself, what is that new discovery? And a larger conspiracy. My lord, I may not be named in the first FIR. I may not be named in the first FIR, what your lordship revealed. There may further investigation, which they have done it. And they seized certain file. That did not prevent them to put me in the charge sheet also. Supplementary charge sheet should have been filed. There is no question of lodging another FIR. What they will do it, again third FIR will be filed. Again third FIR, they may file a third FIR. What your lordship has to see, in that particular case, my lord, RC 12, when the investigating agency has gone and they investigated the matter, they found, my lord, two things. One, they found the facts has to be looked into it. What your lordship has said, sameness has to be tested. In that,
No, that's from the
yes, that
principle
your
of law.
lordship has
I'm
seen
not
the,
saying
no, what the principle laid down by the Supreme Court,
Yes.
sameness has to be
Learn
there.
from that.
Sameness. My lord, in a case wherein RC 12, my lord, what my learned friend has said, my learned friend said that the contract is different. Two contracts are different. Tender, different tender.
Two different
So
entities.
these are two different things that you cannot say it is sameness. What my learned friend want to project before this court.
Yes.
My reply will be that when you investigated the matter, this subject matter is one. Subject matter is one when you investigated the matter. You made a further investigation there itself. Lordship has looked into it that one Priya Chakraborty, 7 lakhs he demanded for a particular contract from United Drill. Now, when his house was raided, my lord, Priya Chakraborty, on the same day on 3/5/2025, then they found 2 gold chain. When it was asked, what is about these 2 gold chain? They said it is in respect of a particular contract which I received from this petitioner. This is the case, my lord. Maybe they have gone. Contract may be different. That doesn't mean that you will file 7 number of case. You could have ended there itself by filing a further investigation. You could have asked and supplementary charge sheet could have been filed. So number one, it cannot be said it is a new discovery of the first case. That contention goes. It cannot be a new discovery. So the principle laid down by the Supreme Court doesn't fit in my case. It is not a new discovery. It is the old story which is reflected in the first FIR. So there is no question of new discovery. Number two, it cannot be of first case, the is in respect of 12, it arises of a larger conspiracy that resulted in filing of a second FIR. My humble submission is that it cannot be a larger conspiracy which leads to filing of a second FIR. That is, my lord, your lordship will find after
The
going
larger
into
conspiracy.
larger conspiracy.
Aspect is not there. according to-
Not there. And that is reflected in the order itself.
Okay.
Maybe, my lord,
That we have
anticipatory
discussed.
bail,
That we have
but
discussed.
some type of material
Time of
which is
decision,
available.
Judge did not find.
Yes.
Anyway, it's
But
not there.
this is not a, two things, my lord. My lord, is one new discovery, which we find. My respectful submission is it is not a new discovery.
And not a larger
Second, it's
conspiracy.
not a
as well.
larger conspiracy. And third, my lord, it is the offense of the first case. Offense of the first case, which arises of two contracts. Offense is one, but in arising out of two different contracts. Where the same officer was present, I was not named in the FIR. Subsequently, they investigate in the same case and they found two gold chain, which they reveal and they seize one file from me, which is related to a particular contract. And which contract? A gen set. What prevented them, my lord, for further investigation, file a charge sheet in that case, supplementary charge sheet. So there was no use of filing of the second FIR. That's my humble submission before this court, my lord. I don't
this has
want-
to be resolved.
Yes,
Oh,
I
it's up
don't
to-
want, I don't want to trouble Babu Bhai also.
No, it's okay.
Anju Chaudhary.
No, this is a
Anju
very
Chaudhary,
good
my lord.
judgment because it is not very long and it summarizes all the various
Yes.
laws.
Anju Chaudhary.
But I have to go through.
My lord, my last Anju Chaudhary, my learned friend has read number of paragraph Anju Chaudhary. Please see paragraph 14 of the Anju Chaudhary's case also.
Okay.
Paragraph 14, last few lines. The paragraph 14 of Anju Chaudhary. Please see last 1, 2, 3 from bottom. 1, 2, 3, 4, 5, 6. The filing of a report upon completion of investigation, either for cancelling or alleging commission of an offence, is a matter which once filed before the court of competent jurisdiction attains a kind of finality. As far as police is concerned, maybe in a given case, subject to right of further investigation.
Yes.
But whenever the investigation has been completed, a person is found to be prima facie guilty of committing an offence or otherwise, re-examination by the investigating agency on his own should not be merely by registering another FIR with regard to the same offence. My lord, same offence may be two different contracts. My lord, will please keep in mind, it is two different contracts. I am not saying it is the same contract. But when it was investigated, they seize one file arising maybe out of a different contract. But you have, my lord, resorted to arrest Priya Chakraborty not in connection in one tender, another particular contract where award was given to me. And that is a specific averment objection you have raised in the first FIR. Specific averment. During the search, we recovered two gold chains. While we went to the house of Priya Chakraborty, we arrested Priya Chakraborty. Out of that, two gold chains were recovered. And this is in respect of a contract which was given to Mr. Tushar Kasera. That was the case, my lord. So my humble submission is that it is a case that is maintainable, my lord. It is will be definite maintainable depending on the merit of the case your lordship has to examine.
Please, Your
I am deeply obliged, my lord.
The nature of both the offences, one is tracked and another one is.
I understand. I've noted down
One
all
is
that.
at different jurisdiction. This one is as
I
different.
noted down all
It
this.
it cannot be
These-
mingled together.
This will never end. Trap
No,
means when you go for a trap, particular to go to a particular person, you trap that person. Thereafter, you investigate.
Person to a demand.
Yes.
Illegal
wha-
demand.
What
Trap happens.
Yes, a demand, and my lord, thereafter you investigate.
But
You
like
can't
this,
say trap
look,
is
see-
different. You investigate the matter. Once investigate, you arrested pairs. Whatever you found from his house, two gold chains were recovered.
That is
Yes.
collusive, two
Yes.
persons are in.
Well, I am deeply obliged. sir.
No, thank you. Good learned submissions on both sides. Learned submissions on both sides. Thank you.
Deeply obliged.
টেবলা মাৰি থব দেই এইটো লিখি দিব learned senior counsel Didas M Kumari 9 tested by N Chaudhary reserve with a week hopefully assisted by N Chaudhary মজুমদাৰ টেবলা মাৰিব দেই ওলাই যাব নহ'লে অ'কে আমি ফিক্স কেইটা আছে এইটো এই দুটা এইটো এডমিট কৰি দিব পাৰিলোচোন আমি এটা যে চাবমিট আছে ক্ৰিমিনেল এপিল
Number 16.
Lordship, and legal aid counsel was here, my lord.
you are legally
No,
counsel
no, for respondent number 2, legal aid counsel was
Okay.
here. He has informed she has some meeting, my lord, I think.
anyway no we can close also no issues
Some interviewer.
it is informed that the legal aid counsel is preoccupied with another matter at the moment. Or let us adjourn it today. Then?
Yes, yes,
Oh, matter. This is the matter. When should I fix the adjourn? It's quashing matter, right? It's quashing. ERC.
Interim order in there.
No, that's okay. No problem. Interim order, wide date, wide order dated so and so stands extended till the next date of listing. When should we fix it, Mr. Professor?
The next, my lord, any date, my lord, only my lord, I have gone through the my lord TCR, my lord, where my lord it is found that my lord.
TCR has come.
Yes, my lord, the entire CD is not available.
Huh?
Along with the endorsement and all, my lord, my lord. And
Very small
the-
compilation.
There are, my lord, 7 numbers of PWs. One is the IO of the case. Even IO statement is also not there. The rest, my lord, only
The petitioner is seeking quashing of the criminal proceeding.
Yes.
Which has been charge sheeted.
Yes, ma'am. That is her statement.
Mm.
Statements are available of my lord. That is the 5 numbers
That's
of my
okay.
lord
Mm.
prosecution witnesses, my lord.
This will be sufficient, I think. Will it be
We
sufficient?
can go, my lord.
Yeah, okay.
Then otherwise, IO statement is not there. Rest the 5
problem.
witnesses are there, my lord.
Can manage.
Fine.
Bijita is not here, no?
Yes,
Today. Another day, a list after 2 weeks.
That may be fixed, my
You can suggest a date.
After 30, if possible, my lord. Eid is coming.
Oh, yeah,
After
no problem.
30. Any date after 30.
It is on 27, right? It will show.
Yes, yes, ma'am.
So after 30, do you want? No problem.
The month of June, my lord, any day.
It'll be on 5 June. 5 June.
The interim order should be cut.
Interim order, first fight so and so stands extended till the next date of listing.
Highly obliged.
17.
Petition criminal.
It previous your lordship, my lord. My lord, here, my lord, we have approached this honorable court under my lord certiorari jurisdiction under Article 226, my lord. My lord, challenging the FIR.
Okay.
Lordship on
Against the
the
petitioner on the basis of preliminary inquiry report by Deputy Commissioner Nalbari. So the petitioner is agreed by the FIR.
FIR. Because of the fact, my lord, the FIR, my lord, which was lost is 72, is the, my lord, that the departmental inquiry that was carried out, that the, on the basis of the report of the
inquiry report, my lord, this FIR was lost. FIR says nothing, only the report of the DP. So, my lord, after the DP, my lord, I have been, my lord, given punishment terminated from service. So thereafter, my lord, I approached the honorable court.
Anyone appearing, Mr. Who's government is read petition, so.
My lord, PHA department, they appears in this matter. my lord.
Government advocate must be representing all the respondents.
Yes.
right? No private respondent.
Petition criminal, my lord.
No, yes, no private respondent, obviously,
Yes,
no?
no private.
No private. Okay.
And my lord, the standing counsel PHC is also shown, my lord, in the course of this. my lord.
So is it? Oh, so
Department.
GA
Why not?
Assam and standing counsel PHC. Let us, should I read the FIR?
No, because Lordship, in that case, since they are also not there, in the last occasion, kindly seen our no order, my lord. On that day also, they were not there. If they don't appear on the next day, my lord may hear this matter, some observation may be made. I am also waiting for this matter only, my lord,
Understand.
because just for refreshing your lordship, just 2-3 submissions, my lord. That on the basis of the department and inquiry, I was given punishment, my lord, and then I approached this honorable court, and the honorable court passed the judgment, page 44. My lord, here in this judgment, the termination order has been set aside and directed the authority to go for a fresh inquiry.
Achha.
My lord, there are 14, page 53 of the judgment, on the basis of which the so-called notice, the DP was initiated and the inquiry report was given and the punishment was imposed upon me, my lord. That there has been some fault and the punishment of the para 16 now again, my lord, for reasons stated there, the court is of opinion impugn order dismissal from service. The 14-12 is vitiated by arbitrariness and illegality. Now, my lord, para 17, while doing so, the court, the honorable court directed, okay, you do the afresh inquiry within a period of 6 months. Now, pursuant to this order, my lord, they have reinstated me. They have gone for fresh inquiry. My lord, in between, my lord, this order, kindly see, my lord, this date, my lord. Judgment dated 27/2/2025. My lord, FIR date, kindly have a look again, my page 72, 2/5/2025.
Fine, okay. February and then May. They filed the FIR in May.
Yes, May, 2nd of May, my lord. My lord, this judgment, whereby the honorable court say, set aside the termination order and ask the department to go for a fresh inquiry because the DP, that original inquiry, the report is no more there after this judgment, my lord, after 27th of February 2025. My lord, without having a fresh inquiry report, now by violating this judgment, my lord, 27%, but they have, my lord, maliciously, my lord.
It was set aside, so that earlier inquiry thing is not there.
As of that,
So on
my
the
lord,
basis of that, they filed the FIR.
yes, my lord, this was in violation of the judgment, and therefore my submission is that, my lord, that when the act on the part of the respondent authority in lodging the FIR is illegal, arbitrary, and my lord, completely abuse of process of the court, my lord. So the initiation of the proceeding is malafide, and therefore, under my lord heading 5 of this State of Haryana versus Bhojanlal case, my lord, this case clearly covers, my lord, that you cannot put the cart before the horse, my lord, whereby this, where a criminal proceeding is manifestly attended with malafide or where proceeding is maliciously instituted. Well, after setting aside a departmental inquiry and thereafter you have forwarded the departmental inquiry report to lodge a FIR. So therefore, I, my lord, challenge this FIR on the ground, initiation of proceeding, abuse of process of the court.
I get your point.
My lord, that's the case, my lord. Otherwise,
Uh,
my lord, may hear this matter on next 14, my lord, if lordship, so please, my lord.
We can fix another date, yes. Yes.
Let them be present, I don't mind.
I think case diary would be necessary, right? Case diary.
My lord, all the matters are there, only the FIR. Closing, because they have not filed
FIR, actually, quashing of the FIR, we have to just see on the face of it,
my lord,
giving wider principles.
my lord,
But usually we call for the case diary.
my lord.
Mr. Busso, the government advocate, how can the how will they procure the case diary?
The WPC
Yes.
criminal, my lord, it will be, my lord, procured by the, my lord, office of the senior government advocate, my lord.
It has to be procured.
My lord, therefore,
That
in
is
the
the thing,
first order, my lord.
My lord, or my lord, a scroll will be given. I just came out from the courtroom to find out if some government advocate is there.
I will
didn't
inform,
notice,
I'm
That's not a problem.
I will.
But should we call for the case diary or not?
My lord,
Because
because-
FIR quashing
My lord, that is the, my lord, for the quashment of the FIR, my lord.
is necessary.
So it is necessary because
But
FIR is not
usually,
the.
though we have to see on the face of it.
Yes, my lord. My lord,
Anyway.
the administrative part and my lord, the bar I am, my lord, submitting because we are not the party, otherwise we
Yes,
can call from
yes.
the
So if it
Lordship.
has to be called, it has to be through the office of the senior government advocate.
Senior government advocate.
My lord, that's what the 5/3/2026 order, my lord.
Uh,
That order is already there to directing them to file affidavit to bring on record the
Yes.
whatever materials.
Yes.
By the next that, if they follow this order and file it well and good, if they don't file, my lord, on the next that we will consider by your lordship, my lord, because next that will be proper, my lord. If they want to file the affidavit, they can.
None appears on behalf of the respondents. So, Mr. Das, learned counsel has drawn my attention to the order dated, previous order dated 5/3/2026. The respondents are at liberty to file any affidavit. So further, the case diary of, what is the case number?
Yes, my lord.
Yeah,
Yes.
case diary of so and so case number case
FIR
number may be called for through the office of the senior government advocate.
vigilance PS case now, my lord.
Okay.
My lord, in the prayer also page 25 also there, page 424 also, my lord. Vigilance PS case 2025 under section, my lord, 120B. My lord, here, my lord, otherwise I don't mind, they can go for, my lord, filing FIR. But
It's okay. No, someone is aggrieved by affair, you have a right to come.
Yes.
We can, we'll examine for vigilance 11/20. Okay.
on kindly, my lord, on 14, my lord. I was
Once on 14th. Okay, let us, we can hear, but it will be good, even if they do not file affidavit, if the CD is received and somebody appears, you can
My lord,
inform.
I will inform, my lord.
Just
I will
inform.
try to, my lord.
Otherwise,
communicate
the
with
court
the
is handicapped
senior
sometimes.
DA, my lord, but
Handicapped.
this, I think phone is not working.
Today it's okay,
I'll
I
inform.
understand. 14th time. 14th time. Seeing you after a long time.
My lord, so basically civil matters. Obliged, my lord.
Good to see you after a long time, yes.
51.
Oh, it will, no? Okay.
Lordship, this matter has come up for admission. However,
Admission.
we have completed taking our steps.
Mhm.
However, the service is not completed, and I don't think it's reflected by registry.
Just a minute. We can,
Please, Lordship.
we should admit the appeal, I think. What do you say?
But item number 51, today in the morning, I have filed Yogalandama.
Okay, for the respondent, number 2.
Soon respondent.
No problem.
Fixed after 1 week, my lord.
2 weeks, maybe
This
2 weeks.
matter may-
After 2 weeks.
Just,
After 2 weeks.
just, I'll come to that. Yeah, it's a check.
Yes, ma'am.
So it's an appeal against acquittal.
Lordship.
Yes, yes. Yes. Mr. Jamal.
No, I'm appearing on behalf of Mr. Zama. I'm
Hey.
ZH Bora.
Huh?
ZH Bora.
Z.H. Pora, learned counsel for the appellant, who was, and your good name?
M. Islam.
M. Islam, learned counsel, who has entered appearance today on behalf of the sole respondent, full stop. The appellant has filed the present appeal against the impugned judgment and order of acquittal dated 5/2/2025 passed by the learned ACGM Goalpara in NI case number 10 of 22. Full stop. Should we admit the appeal? Or
Today, just I have.
or you want to
received in
say
the morning.
something on the admission, since it's an acquittal matter?
Yes.
That's why I asked. Conviction we automatically admit. Okay. The learned counsel for the respondent seeks some time for the admission hearing. Accordingly, prayer is allowed. List on, you take a date.
After 2 weeks, after 2 weeks, any date feasible, but
2 weeks. Let us give a date. 22.
Yes.
22/5 for admission
Yes,
in the admission column.
Obliged.
let's go.
Hearing ID 56.
Just a minute. Just a minute. What code supply this code? Okay. What is this hearing?
Fact, my lord,
It's for IA.
I is there, my lord, for bail probably,
Oh,
and main appeal is there against conviction, my lord.
okay.
In fact, I am appearing for respondent number 2. In fact, my lord, I have received the notice, but without the copy of the IA and as well as this, my lord, appeal memo, my lord. I have asked them to furnish the copies, my lord.
I'll provide those.
The original TCR has been received.
Yes, Lord.
The Mr.
Yeah, Muslim Lord.
M. Hussain and
JC Bora, my lord.
JC Borak for the respond number 2. The appeal was admitted on 11/3/2026. The original TCR has also been received in the meantime. Paper book is not necessary. No? Okay, we can manage. Always convenient, but here there's too much burden. Evening. Paper book. Oh, fine.
Order is to that effect there, my lord, for preparation of the paper book, my lord.
Is it there? Oh, I've already ordered. As the TCR has been received, so the registry may prepare paper book. Full stop. List the matter
After, my lord,
in
preparation.
the orders column after preparation of paper
Yes.
book. Full stop. Thank you. Bora learned counsel for the Mr. Bora learned counsel for the respond number 2 submits that he may be furnished set of copies of the appeal and
I have been furnished today, my lord. Now, my
okay.
lord.
He's been furnished today, only today, and praise for fixing the matter on another day. We'll hear it 5 years and 5 years. No?
Yes, Lord.
How long he has been in custody? Approximate
7 months.
7 months.
20 days.
Okay. So, okay, no problem. You tell me, when should we fix it? Last week of May?
Yes, Lord.
After your Eid? Or in June? We can fix it on
First week of June, Lord.
first week of June. Or, sorry, precisely. 3/6.
Yes.
Wednesday. 3/6. Actually, if it is only IA, it comes for orders. It's come for hearing. If it is only IA,
Yes.
it is
In fact,
it
this
comes
should
for
not have-
orders.
Should not have been listed for hearing.
Yes, in the orders column, list in the orders column.
Because I is still to be
Yes.
decided. Your pleasure.